Like to mention item number 46, they filed their affidavit, lordship. Tomorrow, yesterday, lordship, they served the copy. I need 2 weeks time file my rejoinder, lordship. Item 46.
40? Item 40?
6, lordship.
Mr. Mojumdar, I don't entertain this type of request at the mentioning hours.
Sorry, lordship, because actually, lordship, I have some difficulty for which, lordship, my next door never expired for
Counsel
which
for the
under.
petitioner seeks for
I
an
pray, lordship.
accommodation to file the affidavit in reply. Is there any interim order?
No, lordship. It's a contractor bill, lordship. Lordship asked them file to affidavit. Yesterday they filed, lordship. I received the
Taking
copy
into
yesterday.
account the list of matter on 18th of September.
March of life, lordship.
May I please, your lordship, in item 65, my lord, we have filed an affidavit tomorrow, yesterday, that may be called.
May please, your lordships. It's regarding item number 12 of today's list, your lordships. We want to withdraw this writ petition, your lordships. So, due to some subsequent development, your lordships.
Your name?
H. Burwa, lordships.
On behalf of the petitioner submits that he has instructions to withdraw the instant writ petition. Accordingly, the writ petition stands closed on withdrawal. Interim orders, if any, stands vacated.
May I please, your lordship, in item number 57, my lord, we file a rejoinder affidavit. That may be called for, my
Huh?
lord. Item number 57, we file a rejoinder affidavit against the affidavit in opposition file. File it, please.
Right, petition, lordship. Subject to item number 29, my lord. May be allowed to withdraw the same, my lord.
Same order.
29, obliged.
Lordship, with the concept from the other side, I beg to mention item number 52, Lordship. Lordship, in this matter, Lordship, we have come to know that petitioner has passed away, Lordship. Lordship, sometime may be granted us to take some instruction, Lordship.
When the petitioner passed away,
Lordship, that date exactly, we're not sure. We've been informed that he has passed away. We've been trying to contact them, Your Lordship. But
let's see when the matter reaches.
May I please, your lordship, I beg to mention item number 10. Kindly pass over for that day. Actually, what happened, your lordship, that there is a communication gap between the petitioner and the engaged counsel. I'm the proxy counsel, your answer. So that's why we have to obtain the instruction. That's why at least.
It has come up for orders after 7 years. Let's see.
With the consent of the petitioner, my lord, I beg to mention item number 34. My senior is out of station. He's attending another matter.
Interim order?
Matter may be adjourned for 2 weeks, my lord.
Is there any interim order?
No,
Counsel appearing on behalf of the petitioner for an accommodation. There's also been informed to this court that there is no interim order. Consequently, the matter stands adjourned to be listed on 9th of October 2006.
May I please, your lordship? Lordship, with due consent of the other parties, lordship, I'm praying for adjournment of item number 33, lordship. The respondent number 1 and 2 they have filed an affidavit in opposition, lordship. I have received that. I need some time. I need some instructions for filing my affidavit, lordship.
May I please, your lordship?
Yes.
In item number 33, I'm appearing for respondents 1 and 2, your lordship.
They have filed affidavit, lordship. I need some time to go.
Okay. The counsel appearing on behalf of the petitioner seeks for some accommodation. Is there any interim order?
No, lordship. No.
No, your
Taking into account the list about matter stands adjourned to be listed on 7th of October 2026.
Obliged, lordship.
highly obliged, your lordship.
May it pleases your lordship. Your lordship, I beg to mention item number 44. As my senior is currently in Itanagar bench, your lordship. My senior is in Itanagar bench, so
what?
may the matter kindly be adjourned and may be
Nothing
taken.
doing. We'll see when the matter reaches. What is the matter about?
The counsel.
So we have challenged the demand cum show cause notice dated.
Huh?
Demand cum show cause notice we have challenged, my lord.
You have a stay?
Yes, my lord.
We vacate the stay and have it whenever you feel like.
My lord, they have not filed
The
their
matter of get the stay vacated.
My
Either
lord, they have not filed
We
their
have-
affidavit, my lord.
Oh, what? You are challenging a demand come show cause notice.
My lord.
How? Under section 73. On the ground?
But on the ground that even after paying of taxes, still we have been served with demand cum show cause notice, my lord.
So what? That you can very well reply. Why should this court adjudicate this aspect? We'll look into it when the matter reaches. Who are you for?
BN Gogoi, on behalf of BN Gogoi, my senior, Your Lordship.
Your senior, not necessarily. I know how your CGST works. Ask Mr. Kyle or Mr. Suman Setia to appear if your senior is not appearing.
Yeah.
We'll see when the matter reaches. Next.
May it please your lordship? Your lordship, I beg to, with the consent of the other party, I beg to mention item number 55. On behalf of my senior, your lordship, my senior is sick and unable to appear today. Kindly grant a passover for a day.
Item 50,
5.
you are for the petitioner.
Yes, your lordship.
Is there any interim order?
No, your lordship.
Yeah, I got to there. No interim order. Matter stands adjourned to be listed on 7th of October.
May please your lordship, with the consent of the other side, I beg to mention item 62 and 63 of supplementary list. The contracting council of animal husbandry.
Supplementary list also.
She is not able to come to this court because of some
Hey,
medical
supplementary list to Sini. I don't have a copy of it. Yes, item number.
62 and 63, my lord.
Yeah, what has happened?
Lordship, I am not aware about the court. I am just.
Okay. Don't mention if you are not aware. Be present when the matter reaches.
May I please, your lordship? This item, matter, my lords, has come after almost. We need some time, my lords. I don't know what is the matter about also. I just took the second copy.
There is the order of the Lodima Court of 16/6/26.
What is
I appear for
You are
response
appealing
number
for?
2.
He appears to respond to, my lords.
What happened to the matter? Because there was no stay granted.
There was no state. There was an OTS. I think that OTS now in 2016 itself. So OTS may have left. Now I don't have that up-to-date instruction.
Get your up-to-date instructions. Service has not been meted out upon whom?
Response number 3.
My lords.
How can it be? Response number 3 is the deputy commissioner.
Definitely.
Government was served, my lords, copies. Government was served that time.
Understood, but the fact remains that why you are not present whenever the matter is listed. We
Order
get an
dated.
up-to-date instruction, we'll have it on Friday.
Not-
Mr. So-and-so, as Borai, who appears on behalf of the respondent number 2, shall provide an up-to-date instructions in the present proceedings. More particularly, when there is an affidavit also filed.
Yes,
it
ma'am,
is
they
also
filed an
filed.
affidavit.
What is your stand in the affidavit?
OTS was there, my lord.
paragraph 19.
But the fact remains that you have issued a notice to him,
Madam, yes,
notice to the petitioner
yes.
on 23/6. Legal notice. Then what happened? They have challenged the legal notice.
But they have challenged the order dated second for area dues on 24/5/2006. It's page number 30 of the petition, madam.
No, they are proposing legal action.
Yes.
What is there to challenge this document? No, we are proposing to take legal action, take legal action. What is there?
On
The
page
report reveals that this court, by an order dated 26/2016, did not stay the demand notice dated 24/5/2016 which has been assailed in the instant proceedings. Further to that, it is also seen that it is also seen from a perusal of the demand notice dated 24/6/2016 that the petitioner was informed that if the loan is not settled within 15 days, legal action would be initiated. The report further revealed that pursuant thereto, a legal notice was issued to the petitioner on 23/6/2016, 15. Taking into account that the respondents herein were only contemplating legal action, this court does not find a fit case for entertaining the instant writ petition. More particularly when this court, while issuing notice on 26/2016, did not stay the demand notice dated 24/5/2016. Accordingly, the instant writ petition stands dismissed.
My lord, in this case, I have to take steps, my lord. On the private respondents in item number 2, 3, 6 and 7, my lord. 1 week time may be given, my lord, for that.
Another development. No, there's another. Yes, I should go. I agree.
What is your matter about?
My lord, this is regarding land grabbing, my lord.
What?
My lord, what has happened, my lord? Let me explain, my lord. May I submit, my lord? My lord, the petitioner actually, he availed loans by mortgaging their landed properties. He took the loan from IDBI Bank, my lord. So they, my lord, as they defaulted, my lord, proceedings were initiated before the Debt Recovery Tribunal. And accordingly, my lord, case was recovery certificate issued and the mortgage land were attached. Now, after mortgage land were attached, my lord, the amount was being recovered by selling of the mortgage lands. DRT used to sell the mortgage land to private people by auction, and it was being recovered. Now, what happened, my lord? There was a huge quantity of land was there. Now, some portion of land were encroached by land grabbers, my lord. So what happened was, since it was encroached by land grabbers, the nice portions, my lord, so recovery proceedings came to a halt. We filed a FIR. So since we are the certified debtors, it was our land, it has been mortgaged. But since nothing happened, so we filed FIRs, and in some cases, my lord, FIRs were registered, but nothing happened. So we filed this writ petition, my lord. Our prayer is that, my lord, the land may be recovered from them and be handed over to the Debt Recovery Tribunal so that recovery proceedings should continue. That is our case, my lord.
Mr. M. Kotoki, you know what you should have done.
My lord.
You should have approached the land grabbing tribunal.
Actually, my lord, we came before here, my lord.
Withdraw with liberty to approach the land grabbing tribunal.
But actually, my lord, we
Nothing to that effect. You can very well file a complaint before the land grabbing tribunal, and the land grabbing tribunal will initiate process if need be. I'll only mention that the pendency of the writ petition shall not impact on the question of limitation.
my lord,
Nothing else, take a dismissal right away.
my lord.
Take a dismissal right away. Any whichever way.
Actually, my lord, the problem is.
No,
we can go to the land-
Mr. Kotoki, I am very specific on this. There are two ways.
I understand.
Either withdraw with liberty to approach the land grabbing tribunal. Number two, you have the option of moving under 156(3), which you did not move.
No, my lord.
So therefore, your writ petition is not maintainable, for which we should dismiss it. Take a dismissal, withdrawal, either of it. There is no the third opportunity of an taking time for the purpose of effecting service does not arise. Either of it. Which one?
My lord, then if your lordship will kind of observe on limitation partner, that will do.
গোটেইকেইখনত লিখি এটা এটা বেলেগকে লিখি দিম। Heard Mr. M. Kotoki, the land counsel appearing on behalf of the petitioner.
I'm for R7, respondent 7, my lord. The
Mr.
ACSM.
So-and-so appears, senior counsel, Mr. So-and-so appears on behalf of the respondent. So-and-so appears on behalf of the respondent numbers 1. Mr. Kotoki, what type of writ petition you have drafted? State of Assam represented by the deputy commissioner.
Well, the government.
We are contemporaries doing civil law. Can the state of Assam be represented by the deputy commissioner?
No, in this case, we are only concerned with the district only, that is why.
So what? Is it ever heard of section 80? My goodness. So-and-so appears on behalf of the respondent numbers 1 to 5. The petitioner has approached this court being aggrieved by the inaction on the part of the respondent numbers 1 to 5 in taking action on the basis of an FIR, on basis of FIRs filed by the petitioner for prosecuting the respondents, the private respondents. The petitioner also have sought for relief that the land which is under the occupation of the private respondents be retrieved by the official respondents, and thereupon the said land be redelivered to the respondent number 6, who is the recovery officer of the Debt Recovery Tribunal. This court had perused the materials on record and is of the opinion that the reliefs which have been sought for in the present writ petition under no circumstances can be granted in favor of the petitioner. On account of non-file and non-registration of the FIR, the petitioner ought to have non-registration or for not taking due action on the basis of the filing of the FIR. The petitioner had the opportunity of availing the statutory remedy as provided under section 156(3) of the CRPC 1973, full name likhi. If the petitioner was aggrieved as regards the grabbing of the petitioner's land, the petitioner had the opportunity of availing remedies before the land grabbing land, what is that name?
Assam Land Grabbing Prohibition Act, within bracket points.
Under the tribunal.
Assam Land Grabbing Tribunal.
For the tribunal.
Special Tribunal.
before the special tribunal set out in terms with the Assam Land Grabbing Prohibition Act 2010. The petitioner cannot also, by way of invoking the public law remedy, convert these proceedings into a proceedings for recovery of land, recovery of the possession of the land. Under such circumstances, it is therefore the opinion of this court that the instant writ petition is totally misconceived and not maintainable. For which, accordingly, the writ petition stands dismissed. Before parting with the record, this court, however, observed that the dismissal of the instant writ petition is on the ground that this court is not inclined to entertain the present dispute by invoking the present dispute. And as such, the same shall not prejudice or preclude the petitioner to approach the appropriate forum if so advised.
My lord, actually, at the time of filing the
Land grabbing,
petition,
there is no land grabbing, there is no period of limitation.
my lord, actually, at the time of filing the
Same
petition,
orders
there was no
came-
tribunal.
Huh?
Actually, the tribunal was not established at that time. 16.
2016, it was not.
No. That is,
But the
act was there.
but the CGM was there.
No, the land grabbing.
CGM was also not
No,
there.
that part is okay. This part, my lord, tribunal.
Not this much. AK or the beleg. The beleg.
May it please, my lord. My lord, here in the impugn order, an order of annulment of a patta of way back in 1967 was, without hearing us, it was reversed. We were the original pattadar before 1967. They say that they did not know that it was made sarkari. Later on, it was annual patta was given to us. As of today, we have Miyadi patta over this land. And in the impugn order, the Assam Revenue Board on the first day itself, even without issuing notice, has cancelled order of 1967. Lordship, the order is in page 33. The order says that no serious attempt was made to recover the land revenue, arrear land revenue, and therefore process was not followed. And
Who are you? Who are you?
I am the person who has got annual patta over this land after it became sarkari. Annual patta was issued to in my name. Presently, my instruction is that we have also got periodic patta.
When did you get the periodic patta?
That Lordship, exact date I am not knowing at this. I'll have to take instruction on that. I'm not knowing the date, Lordship.
How could you get a periodic patta when that very settlement, when you have, on one hand, you have got a suspension of this order?
Yes.
You could not have got a periodic patta.
Now, recently, I mean, the case has come up after a long time. And recently, when
The order was suspended.
Yes, yes.
Merely because of the suspension, it does not make that the order non-est. And why the matter has come up after such a long time? These matters should have come up immediately. Somebody has filed IA.
No, IA we had filed only. Actually, the person, the respondent number 1, he expired. And there is that issue is there that we had implemented his other notice was sent. 4 numbers of legal years he has. But out of that, it has come to the notice that 1B has expired. One of the legal year has also expired. And now there is a problem that his legal years we are not able to get because they're not staying in that place. Now, present problem is actually this. Respondent 1 expired, he left 4 legal years, we send notice, and then out of that also 1 legal year died, 1B died, and his legal years we don't know.
What about the others?
Others notice was served.
Notice has been served?
Yes. Lavazima court, many times this matter has come up recently regarding this issue only.
What is the address you have put for the respondent number here?
I mean, it is the same address by which they had filed the case in Revenue Board.
When did you get the annual patta?
Lordship, I'm checking this.
Who is the respondent number 2 in the said proceedings?
2 is Deputy Commissioner.
No, Habibur Rahman. Who is Habibur
No,
Rahman?
Habibur Rahman is us. Summer, no, said proceeding means in the before the Revenue Board. Before we were the revenue respondent to.
So no notice was issued to you?
No. No, on the first day, this order was passed without notice.
How do you know? How did you know about this order? If it was passed against you without notice to you and approached this court? Counsel?
Lordship, I'm not finding any specific paragraph, but maybe from the DC office, from the local authorities, he might have known. Okay, Lordship, para 11, Lordship may kindly look into once of our petition. Because there was a direction, it seems from here that there is a direction to the circle officer to restore the name of Samar Ali.
Hey, flag Z to some. Itu file. Second file to job. Mr. Mr. H. Sharma, you direct the authorities to produce the reports of this. What is your stand out here?
Lordship, from the order passed by the Revenue Board.
It appears that there was no steps being taken for the purpose
Yes,
of,
Lordship.
because they had to, when you go for on account of non-payment of the dues, then you put it to public auction.
Lordship.
These are the records of that in the year 1967 in respect to miscase registered in
That is the findings of the Revenue Board, Lordship.
here. What has happened? This particular Board of Revenue member, he on one hand admits the revision application on the same day
Lordship, on this and dispose also.
and disposes on the
Lordship,
same.
that is,
So we cannot countenance that.
Lordship,
We do one
that is
thing,
true.
taking into account that the respondent number two's estate is represented by the other legal representatives. We set aside this order, directing the year to take it up.
Yes, Lordship, afresh.
I think they are the better
Remand the
off.
matter,
We cannot countenance this.
Lordship.
And till the matter is being not taken up, no further rights have been created on the basis of the annulment order dated 26/1967.
Lordship,
All rights granted shall be subject to the outcome of this revision petition.
Lordship, Lordship.
All right.
Because no right could have been created on the merely on the basis of a suspension of this order. This order, if any right has been created in the pendency of the writ petition, that cannot be there. Because once you get a suspension, that doesn't mean that this order has been annulled.
Lordship.
So and so appears on behalf of the petitioner, Mr. Mr. Sharma, the learned additional senior government advocate, appears on behalf of the
Respondent number 2.
respondent number 2. So none appeared on behalf of the respondent numbers 1A to 1D. It is, however, it is duly taken, this court duly takes note of that initially the respondent number 1 was arrayed as a party to the instant proceedings. But subsequently, on account of the death of the respondent number 1, the respondent numbers 1A to 1D, who
After hearing the
represents the estate of the deceased, respondent number 1, have been substituted. This court also takes note of the office notes, which shows that the respondent number service have been duly meted upon respondent number 1A, 1C, and 1D. And therefore, the estate of the respondent number, deceased respondent number 1, is adequately represented. In the backdrop of the above, this court duly takes note of the impugned order. From a perusal of the impugned order, it is seen that the proceedings, that an order dated 26/1987 or 67,
67.
1967, passed by the Deputy Commissioner Nagaon by memo number 10213-146, was put to challenge by filing an application under section 151 of the Assam Land and Revenue Regulations 1886. The ground on which such an application was filed was that the predecessor of the present respondent numbers 1A to 1D was never informed prior to passing the order of annulment of the patta. This court would not deal with the said aspect, would not like to deal with the said aspect in view of the order which this court proposes to pass. Next. This court also finds it very pertinent to take note of that the application was filed on 4/4/2016. No notice thereupon was issued. Application was filed by the predecessor of the respondent numbers 1A to 1D on 18/4/2016. And thereupon, all of a sudden, on 9/5/2016, which is the impugned order, the learned member of the Assam Board of Revenue, while admitting the application, as would be apparent from the first paragraph of the order dated 9/5/2016, did not consider it necessary to even issue notice upon the respondent number 2, who is the petitioner herein,
Yes.
and disposed of the said proceedings. A perusal of the said order dated 9/5/2016, in the opinion of this court, is not only in violation to the principles of natural justice, but also violates the very mandate of the Assam Board of Revenue Regulations 1962. 1963. And more particularly, Regulation 13 of the said regulations. Considering the above, this court therefore sets aside the order dated 9/5/2016, passed in case number 48 RA Modi /2016, and remands the matter back to the learned Board of Revenue for deciding afresh the said application after issuing due notice to the respondent numbers 1A to 1D. And the petitioner hearing. And the respondent 1A to 1D. Taking into account that this court has remanded the issue, remanded the matter back to the learned Assam Board of Revenue, this court observes that till the disposal of the said proceedings being registered as 48 RA Modi /2016, all rights created on the basis of the annulment order dated 26/1967 by memo number 10213-14, passed by the district commission, the deputy commissioner, Nagaon, shall be subject to the outcome of 48 RA Modi /2016.
Much obliged.
You get that thing done out there.
Yes.
Please, your lordship. My lord, step taken to the respondent number 4 and 5, and accordingly, my lord, as per Loazima report dated, my lord, 10/6/26, service completed, my lord.
What is the matter? Forget about steps.
My lord, matter relating to the, my lord, eviction, my lord. The petitioner, my lord, possessing the, my lord, annual Tojipatta land. My lord,
Who has issued the eviction notice?
my lord, no notice was issued, but my lord, a list was prepared, my lord, pays,
List won't do.
and verbally, my lord, he was asked to.
Heard Mr. So-and-so, the learned counsel appearing. Mr. So-and-so appears on behalf of the respondent numbers 1, 2 and 3. And
2 and 3.
appears on behalf of the revenue department on call.
Revenue.
And appears on behalf of the respondent number 1, 4 and 5 on call. The present proceedings have been filed by the present petition has been filed by the petitioner.
Para 7, my lord.
Challenging the proposed actions on the part of the respondent number 2 and 3 to evict the petitioner. The apprehension of the petitioner was on the basis of the name of the petitioner being inserted in a list dated 12/3/2018, which had been enclosed as Annexure 8 to the writ petition. The learned counsel appearing on behalf of the petitioner submits that in terms with the judgment of the division bench of this court, in the case of Mohammed Salakuddin versus so-and-so, reported in so-and-so, issuance of notice is mandatory prior to initiating any proceedings for eviction. Mr. H. Sharma, the learned counsel who appears on behalf of the respondent number 2 and 3 also submits that in view of the said judgment passed by the learned division bench, the respondent authorities, if the respondent authorities takes any steps for eviction, the same shall be done by issuance of notice upon the petitioner. Considering the above, this court is of the opinion that merely on the basis of the name of the petitioner's land inserted in the list dated 12/3/2018, the petitioner cannot be evicted. The petitioner can only be evicted by following the mandate of law, and more particularly, the judgment of the learned division bench in the case of Muhammad Silakuddin Supra. Accordingly, the instant writ petition stands disposed of with the following observation and directions. The petitioner herein cannot be evicted merely by inserting the name of the petitioner's land, barely inserting the land under the occupation of the petitioner in the list dated 12/3/2018. Number 2, it is observed that if the respondent authorities, more particularly the respondent number 2 and 3, takes any steps for eviction of the petitioner, the same has to be done only by following the due process of law, that is, by issuance of notice, thereby granting an opportunity to show cause as to whether the petitioner has a right to occupy the land in question.
Kindly oblige.
What is the matter about?
41 নোটিশ আছিল না? Matter relates to Lordship by forging the check according to the petitioner, his amount has been transferred to the private respondent's Lordship. So regarding that inquiry, Lordship, he is not satisfied with the inquiry done by the police. Accordingly, Lordship, he has approached this honorable court. And at that time, Lordship, in 2019, during that time, Lordship, we have received the status report. And according to this status report, the WT messages were sent to the concerned police stations for arrest of the respondent number 5 and 6. Till that, Lordship, in 2019, we have received that instructions. So according to
All. It appears on behalf of the respondent number
Lordship,
2, 3, 4,
2, 3, 4,
1 also. 1, 2, 3.
1, 2, 3, 4.
So Goswami, you are appearing for?
Respondent number 7, bank.
Mr. P.C. Goswami appears on behalf of the respondent number 7. This court duly takes note of that the petitioner had been granted various opportunities to take steps upon the respondent number 5. However, the petitioner have not chosen to do so. Be it as it may, this court also finds it relevant to take note of the reliefs which have been sought for by the petitioner in the present writ proceedings. The petitioner's grievance is on account of the investigation in Lotasil PS case number 296/2013, being not properly carried out. And for a direction that the respondent authority should arrest the private respondents. This court have duly taken note of the affidavit which has been filed. Taken note of the status report
Lordship.
dated
Lordship, there are
taken note of the status report.
two status reports are here, Lordship.
It is the opinion of this court that if the petitioner is not convinced with the investigation so carried out, the remedy of the petitioner lies before the concerned jurisdictional magistrate.
Lordship.
Further to that, it is also the opinion of this court that as to whether the private respondents should be arrested or not comes within the ambit of the investigating agency. And it is not for this court in exercise of powers under Article 2 to 6 of the Constitution to pass directions to arrest the accused. Under such circumstances, this court does not find any merit in the present proceedings for which the instant writ petition merit for deciding the present proceedings under Article 2 to 6 of the Constitution, for which the writ petition stands dismissed. The dismissal of the instant proceedings shall not affect the investigation or any further proceedings thereupon in connection with Lotasil PS case number so and so. None appears on behalf of the petitioner on call. It is seen that the petitioner had not appeared on the earlier occasion and have also not taken any steps, as would be seen from the order of the Lozima court. It therefore appears that the petitioner is not interested in pursuing with the present proceedings, for which the writ petition stands dismissed for non-prosecution. Interim orders passed earlier stands vacated. Yes, Mr. Purkasta, what is your matter?
In this case, my lord, as per the Lojama report, my lord, notice on response number 9 is complete. Response number 8.
Huh?
Notice on response number 8 is complete as per the last report of the Lojama. Office note 19/7, 19/6/2026.
Why the writ petition is 109 pages?
Lordship, kindly appreciate, my lord, because we
You have also got another follower. That day I mistakenly thought that it was your petition when I got a big petition.
my lord. My lord,
Then I told, is Mr. Purkasta appearing? He said, no. I said that there is somebody following the footsteps of Mr. Purkasta. Anyways, what is your prayer? Let us see. the
Prayer, prayer is, my lord, that earlier we have approached this honorable court. And my lord, we have challenged the very constitution of the board of directors. Respondent bank. And on the day of my hearing,
And the consequent action in refusing to entertain the representation dated so and so as sought by the petitioner and all other. Now, who is refusing?
refusing is, my lord, respondent bank.
Huh?
Respondent bank. Initial
Respondent number?
direction was given by this honorable court by relegating the matter back to the respondent bank to examine our grievances. That was not done.
Who is respondent number 10?
Respondent number 10 is the, my lord,
No respondent number 10. No, sir. We have till respondent number 8.
8, respondent number 8 should have been.
And who is to look into your representation?
My lord, one-man committee, joint, juvenile joint register.
Is the one-man committee?
He was one-man committee.
Why the one-man committee is continuing?
Because at that point of time, my lord, when we approached this court and matter was heard finally, then they produced a notification saying that term of the board, my lord, is completed. Then the matter was remanded back with the direction to examine our grievances. The question is, my lord, whether we being the
So where is our High Court's order?
High Court's order is at page 111.
Huh?
111.
170.
No.
What?
11111. No, sorry, my lord, I'm sorry,
I
160.
know better.
166.
169.
Right. Yes.
168. Let us see the High Court's order. What is it? Mr. So-and-so, in the representation, the primary grievance of which is pertaining to the election of A class shareholders in the previous election, AGM of the society held in the year 2018. Has also assailed the bylaws of the society by containing certain clauses of same were discriminatory and therefore deserves to be set aside. When the matter is called up, Mr. Kusami, the learned counsel for the respondent, have produced a copy of the notification they have to submit it on near of the board. The respondent number 4 herein. The board has been dissolved and a one-man committee, so has been appointed to manage the affairs of the union. Cooperative Bank Limited. According to Mr. Goswami, nothing further. Similar is the stand of Mr. S.K. Talab after going to by granting liberty to the petition to agitate it before the competent authority as and when fresh AGM elections are notified. By taking all such grounds as may be available to him under law. In the process, the petitioner would also be at liberty to urge before the authorities the validity, applicability of the provisions of the bylaw. This order, the last portion of this order has been given because Mr. Purkasto, you appeared.
Not that, my lord.
Otherwise, there was no necessity of passing that order.
Also, kindly
First
appreciate
of all, Mr. Purkasto, you know,
My lord.
what is the role of a one-man committee?
One-man committee is to, my lord, conduct the AGM for the purpose of constitution of the.
Within 90 days.
My lord.
41-6, nothing more than that.
Right.
Isn't it? So that is what, now, once the AGM is looked into,
Right.
can there be an amendment looked into by the one-man committee? No. No, impossible. So your very representation which is being submitted to the one-man committee is absolutely nothing.
Then
Now, if you have to there, you have to go there, change the bylaws by way of an amendment. If you agree with the bylaws.
No, they
Yes.
have amended the bylaws. They amended the bylaws as a result of which all class A shareholders were debarred from taking part in the election.
Understood. So therefore, that action, if the debarment has been given or class A action shareholders have been impacted by amending of the bylaws ought to be challenged before the appropriate forum. Isn't it? You challenged that before this court. This court did not do anything.
Right.
But allowed you
So
to approach the authority and you approach the one-man committee. Can he do anything? Tell me.
That's right, man. At that point in time, because there was no regular board of directors.
Understood. So therefore, who should you have approached? You should have approached the register. That look here, these bylaws have been amended. This amendment which has been carried out is not in consonance with the bylaws or the Cooperative Societies Act. This is what you should have done.
Absolutely right. So,
But what will the one-man committee do? And in fact, that is why I'm saying, Mr. Purkasta, because of you, the last portion has been given.
fine. So Lordship may modify the order, directing us to approach the register and raise our grievance. Because we have a right under the amendment bylaws to take part and to contest in the election.
Now what has happened?
Now they constituted my new board of directors.
So now the board is there
What is there?
and you are out.
I'm out.
You are a shareholder.
Yes.
So if you are a shareholder, if you are the shareholder, so therefore what happens next is you can very well fight it out there, carry out another amendment. It is democracy.
They may not, they
Why do you want the register's involvement? Who appears for the corporation department?
Earlier, Mr. B.D. Krishnan.
Senior MD Bora is on leg in court number 5. We are 4% department.
Because of you, I have till now taken up all these 14 matters, right? 13, huh? Till 12, it has already been dismissed. You want an adjournment here. This is another one which should have been dismissed. Item 13. So, anyways, we get hold of another corporation department's counsel. We don't need you. Ask anybody. Their presence is not required otherwise. Get hold of any corporation.
Yes, my lord, therefore.
But you don't have a case, Mr. Counsel.
My lord, therefore.
Forget about why are you spending money unnecessarily making this spending area. You fight it out there.
Lordship kindly appreciate.
Either fight it out there or approach the register. Or approach the register.
Right, absolutely right.
You cannot approach the one-man committee who has no business
They,
at all.
at that point in time, they might have some wrong conception and they approach the one-man committee. So Lordship, for the answer just modify the order, directing us to approach, because otherwise this problem will continue.
I won't modify the order. I will say that the liberty which was granted, you have approached the wrong officer. You should have approached the register for which Mr. Purkasta submits that to withdraw with liberty to approach. I say he may withdraw and liberty given him to approach the register.
In terms of the earlier order of the court.
That too, obviously that has to be a
give a
prelude.
reference because
I'll
otherwise
give you a prelude to that.
Give
Because
a
the
reference.
earlier order says is disposed of as infructuous by granting liberty to the petitioner to agitate his grievance before the competent authorities.
Right.
So you say that the competent authority
At
ought
that
to
point
have
of
been ought to have been the register.
No, no, at
But you have incorrectly approached the one-man
Right,
committee. And therefore now you want to approach the register. Okay, liberty granted.
Yes.
Isn't it?
Otherwise, my lordship.
That
there
is the
must-
only way out.
there must-
Otherwise, to save yourself from the embarrassment, and like the earlier judge
Yes,
also did not like to give let Mr. Purkasta leave the court without anything. I also want to give something.
I know, guys.
Heard Mr. A.K. Purkasta, the learned counsel, appearing on behalf of the petitioner and appears on behalf of the respondents on call. The present petition has been filed by the petitioner challenging the inaction on the part of the respondent authorities, more particularly the respondent number 8, in considering the representation submitted by the petitioner on 9/10/2023. Mr. A.K. Purkasta, the learned counsel, appearing on behalf of the petitioner, submitted that in pursuance to the order dated 27/9/2023, the petitioner had passed in WPC number 3178/2022. The representation dated 9/10/2023 was submitted before the respondent number 8, who was the one-man committee. And this representation have not been taken into consideration.
Not even examined, madam. Not even examined, not even looked into.
Not been taken into consideration, that is. This could have duly taken note of. The respondent number 8 was only a one-man committee whose role in terms with section 41(6) of the Assam Cooperative Societies Act 2007,
Right.
is only to hold the elections within a period of 3 months. 90 days. It is therefore the opinion of this court that the submission of the representation dated 9/10/2023 before the respondent number 8 cannot be construed as submitting the representation to the competent authority. The representation the liberty which was granted to the petitioner to submit the representation ought to have been the register of the cooperative society. Mr. A.K. Purkasta, the learned counsel appearing on behalf of the petitioner, submitted that in that view of the matter, the petitioner would not like to further pursue the instant proceedings and be granted the liberty to submit the representation before the register of cooperative society. And in the circumstance such representation is submitted, the register should consider the same and pass orders within a time frame.
And madam, we liberty.
No more. I gave you more.
Liberty be given to
Taking
raise.
into
you can-
account the above,
Madam,
the instant with petitions therefore stands closed
Madam,
on withdrawal. Pusto.
madam.
The withdrawal of the instant with petition shall not preclude the petitioner to submit a fresh representation
Raising all
before the
questions.
register of the cooperative society. Placing the grievances of the petitioner. It is further observed that in the circumstance such representation is submitted, the register of the cooperative society shall duly consider the same within the ambit of the Assam Cooperative Societies Act 2007 and the rules framed therein under.
Now it seems to be complete order.
Closed.
Now it seems to be a complete order.
Huh?
Now it seems to be a complete order.
You are appearing.
Lordship, I'm appearing, actually, MD Bora is appearing in this matter, siege on legs, your lordship.
I'm not concerned. Who is aware? I'm asking, are you appearing?
Lordship,
for the
if I can
purpose?
appear.
When say appear.
Obliged.
Obliged, lordship.
What is this IA for?
Well, I am that private respondent, my lord. He's already died, my lord. Matter has become infructuous, my lord. He has died. I don't know, respondent number 4, who has filed the IA. He has already died on the 12th May 2025. So it's a fight between the post of secretary. I think. So my lord, if he,
Under section 1, allowing the applicant. Who is the applicant?
my lord, there here the respondent number 4.
You are respondent number 4.
Yeah, the who died, my lord.
Oh, no, so you're appearing for a dead person.
6, my lord. 6, yes. Yes,
A dead person.
dead person.
Now, impugn order. The learned counsel appearing on behalf of the applicant submits that unfortunately the applicant expired. In view of the said submission, the instant application is not it cannot be pursued with, for which the instant application stands closed as infructuous. Now, your petition.
Yes, my lord, page, my lord, 144, my lord, 144, the impugn order, my lord.
Yes, order.
Yes, order, registered.
Who are you?
My lord, I am the present secretary of the particular society, who is working, my lord, since 2001 to till date, my lord.
Now Abdul Hamid Chaudhary had expired.
Expired.
This order.
So
Now-
this is the,
This
so
is
this
the order.
has already become infructuous.
Yes, this order was in favor of the, my lord, respondent number 6, who has already died.
Understood. Then now this order has become infructuous in view of the death of Abdul Hamid Chaudhary.
That's
Yes, yes.
death certificate.
So now the register, now the cooperative society
Malad.
who is there has to take a fresh decision
Fresh
to appoint,
Yes, ma'am. Yes, ma'am.
Yes.
isn't it? You are challenging the order of 21/6/2024,
My lord.
isn't it?
Yes.
Now, heard Mr. M.U. Mondal, the learned counsel, appearing on behalf of the petitioner. Mr. None appears on behalf of the corporation department. Who are you?
On behalf of SK Talkara, KS Udhya.
None. Standing counsel cannot. Okay, none appears on behalf of the corporation department on call.
2025.
Who appears for the cooperative society? None. Mr. B. Sinha appears, Mr. B. Sinha, the learned counsel, who was a learned counsel for the respondent number 6, submits that the respondent number 6 had expired on
12/5/2025.
12/5/2025.
25.
The present petition has been filed by the petitioner assailing the order dated 21/6/2024, issued by the Register of the Cooperative Society Assam, as well as the impugned letter dated 29/6/2024, issued by the ARCS Karimganj and the consequential orders. This court duly takes note of that the order dated 21/6/2024, the Register of the Cooperative Society had upheld the decision of the managing body dated 1/2/2003, 2023, must be 23, for reinduction of the respondent number 6 as secretary of the East, or secretary of the
Badarpur Cooperative.
respondent number 5. Pusto. The said order, however, no longer survives in view of the death of the respondent number 6, as already noted above. The consequential orders which were based upon the order dated 21/6/2024 also ceases to exist in view of the fact that the order dated 21/6/2024 cannot hold the field as on date. Accordingly, the instant writ petition, therefore, thereby challenging the order dated 21/6/2024, as well as the other consequential orders, had become infructuous. It is Mr. M.U. Mondal, the learned counsel, however, submits that there would be now a requirement of the managing committee of the respondent number 5 to the board of directors, no, not the managing or the board of directors of the respondent number 5 to choose to select and appoint a fresh secretary. Taking into account the said submission, this court observes that in view of the instant writ petition instant writ petition has become infructuous. The board of directors, respondent number 5 would be at liberty to take steps for selection and appointment of a secretary as per the provisions of the Assam Cooperative Societies Act 2007, the rules framed therein under, as well as the bylaws of the society.
I'm developers.
2, 3, and 4. Okay.
I'm sorry.
Lordship, in item 13, my lord, I was on late, lordship. So,
There was another person who.
yes, I have sent my colleague. Oblast.
Yes, Mr. Shom.
Lordship,
I've seen you after a long, long time.
Lordship.
Yes.
Affidavit has been filed, Lordship.
You got some money.
No, Lordship.
Now you have acquired the land,
My lord,
but you have not paid the compensation.
the entire compensation is not been released. my
How
lord.
much you
By
have
the-
paid?
my lord, only 60 lakhs we have received. My lord, finance approval has been received. For rest of the amount, my lord, we are taking up the
How
matter
much
with the
is the
finance.
petitioner entitled?
That I have to take instruction, my lord. That is not very clear.
Have you seen the order?
My lord,
The order speaks about it.
my lord. But my lord, that out of the 60 lakhs, whatever, what amount the petitioner has received, that is not,
Okay, but the question here it says the award has been passed. Additional AG, by producing the instruction received by the junior government advocate from the office of the additional deputy commissioner on so and so to the effect, the compensation of the petitioner has been calculated at rupees, how much? 14 crores,
Lordship.
29 lakhs,
Well, there are-
62,343.
four acquisition cases. I don't think, my lord, he will be my lord, entitled to the entire amount. The land acquisition case number 1, 2, 3, 4, and 5, where the 5 cases for acquiring the entire land. my lord. 14 crores is not the entitlement of the petitioner alone, my lord.
Submitted a proposal for sanction of funds amounting to so and so in connection here, which was processed according to the applicable procedure. The amount has been reduced. Now, who is the person who is impeding upon the compliance of the order?
The finance department,
We record it
not as per
at
the,
your submission so that he can impede the finance department. And how much are you entitled to, Mr. Som?
Lordship, in total petitioners were 20 in the read petition. In the read petition, 20 petitioners were there.
but only one has come before this court filing contempt.
And your lordship, in the present petition, 3 petitioners have filed this present contempt.
Three petitioners have come.
Lordship.
So how much is the petitioner's entitlement? And where, has there been an award passed? My
No,
question.
no, my lord.
Huh?
No, my lord. What I have, instruction is there. From there, it is not clear, my lord, whether any award is passed and justifying the amount, my lord, of each of the.
This is the preliminary cost of land acquisition under the Assam Land Requisition and Acquisition Act. This was made in the year
2000, my lord.
Huh?
Acquisition, the land LA case of 2000, my lord.
Has the award been passed or not? If the award has not been passed, then obviously, and you have no money,
My lord, let me come back day after, my
then
lord.
the interest will accrue, keep on accruing. And how much is the petitioner's entitlement?
Lordship, here Lordship, 3 petitioners have appeared, but no award in the LA case, your Lordship, no award were passed. So jointly, 3 petitioners and along with other 17 petitioners appeared before this honorable court. 20 petitioners jointly appeared. And because,
If the award has not been passed,
Lordship,
as proceedings under section 9, notice has been issued.
yes, on that ground, your Lordship,
Yes, my lord.
Order which has been passed by the learned coordinate bench does not contain these particulars.
yes,
Well,
Notice.
Mr. Som, the problem which arises upon your case is this, in view of a judgment passed by the Supreme Court,
Lordship,
that if the non-compliance is not on account of the contemner, contemner cannot be said to be in willful or deliberate violation of the court's order. So your contempt proceedings therefore could be dropped. That is the biggest problem. And the biggest problem arose because of that order. Now it is not known as to whether any award has been passed, because the award has to be passed in terms with the Land Acquisition Act of 1894. Isn't it, madam?
My lord, it is, my lord, 1894.
So the land award has to be passed
My
in
lord.
terms with section
My
11 of the 1894 Act. That award has not been passed. So land has not therefore vested upon you. You want to give back the land?
It is already acquired in 2002. Your
I know, my
Lordship.
lord, project is also complete. my lord.
Complete,
Hmm.
Lordship.
Anyways, give back the land to him, demolish the thing and give it back to him. Can make good use of it. Let them acquire as per the 2013 Act now. Now we'll get more better compensation,
Lordship, 2013 Act, Your Lordship.
isn't it? It was done in 2020.
2002,
2000.
Lordship.
2002.
2002.
And we are 26 years down the line, they have not made the payment.
Lordship.
The present contempt application arises on the basis of an allegation, on the basis of allegations that there has been willful and deliberate violation of the order passed by, of the order dated 04/2024 passed in WPC number 1039/2014. From the materials on record, it is seen that 26 years from today, the possession of the land of the petitioners were taken. There was no acquisition proceedings initiated. Subsequently, when the writ petition was filed in the year 2014, espousing the rights of the petitioners under Article 300A of the Constitution, certain proceedings were initiated under the Assam Land Requisition and Acquisition Act 1964. In the year 2020, so they have initiated right back in 2000.
2000, my lord.
When writ petition was filed in the year 2014, this court was duly informed that a process had been initiated for making payment of the dues to the petitioner, making payment of the compensation payable to the petitioners. And in that regard had produced before this court an assessment, an estimate, so prepared by the Deputy Commissioner, District Magistrate, Hojai, Deputy District Commissioner Hojai, which was to the tune of rupees 14 crores 29 lakhs 62,343.97 paisa. This court, taking into account that a process had been initiated for making payment, directed the concerned respondent authorities to make payment, to take appropriate steps directing the requiring authority, that is the Water Resource Department, to consider the proposal received from the Office of the District Commissioner Hojai and make the necessary funds available to the District Commissioner Hojai so that the payments of compensation can be disbursed to the petitioner. This court further directed that the said exercise be completed within a period of 6 months. Taking into account that even after the period of 6 months, nothing has been done in that regard. The present proceedings have been filed. This court duly takes note of the affidavit which has been filed by the who is he? Secretary. Secretary to the Government of Assam, Water Resource Department, wherein it is mentioned that sometime in the month of August 2024, the district commissioner had submitted a revised demand of rupees 639.04 lakhs. And pursuant to the meeting, another revised estimate of rupees 589.08 lakh was furnished by the Deputy Commissioner, Gojai, in Form 7 under the Assam Land Requisition and Acquisition Act 1964. On the basis of the said revised estimates so submitted, proposals have been submitted to the Finance Department for release of the funds. And the Finance Department have not taken any steps for release of the funds. From a perusal of the above, from the perusal of the affidavit filed by the Secretary, Authorised Department, it therefore transpires that on account of the Finance Department not of the Government of Assam not providing the necessary funds, the sole respondent is not in a position to disburse provide funds to the district commissioner for disbursal of the funds to the petitioners. This court also appears from the said affidavit filed by the sole respondent that the non-compliance of the order dated so-and-so passed in WPC number so-and-so is on account of the interference by the Finance Department. It is the opinion of this court that taking into account the said stand, the petitioner would be well advised to file appropriate application to include the Commissioner and Secretary, the Government of Assam, Finance Department as a party to the instant proceedings. Mr. A. R. Som,
Lordship.
the learned counsel appearing on behalf of the petitioner submits that the needful would be done. Lists the matter upon such application is filed.
Oblige, your Lordship.
These three matters will proceed next week, my lord. My instruction is that some funds has come, but it is not clear whether for this scheme funds has come or some other schemes, my lord.
No funds.
And the funds has come, my lord, for this scheme or some other scheme, that is not clear, my lord. These are WhatsApp instructions, my lord. Let it come in next week, my lord. I will get the entry instructions.
Mr. Espora, who appears on behalf of the respondent, submits that though the Government of Assam has made available funds, but the Commissioner GMC is yet to ascertain as to whether the funds so made available are in respect to scheme under which the petitioner carried out the work. He therefore submits that a week's time may be granted to ascertain and place an updated instruction. List this matter again on 19th of August 2026.
Highly obliged.
Yes, what is this?
Well, the petitioner has prayed for a direction to furnish him information on the RTI. In fact, Lordship has directed me to obtain the instructions. My instruction is that all the information have been provided and the person to this State Commission's order, informations were given and the Commission has accepted that explanation and accordingly closed the petition proceeding.
None appears on behalf of the petitioner on call. Mr. D. Nath, the learned senior government advocate, appears on behalf of. Yes, you have been provided all informations.
My lord, that is not correct, my lord. Last occasion also that letter was produced before this honorable court.
No, well, kindly see the second page, my lord. The instruction first page is written to me and the second page kindly see.
The RTI application dated file when namely Sanjeev Tamuli sought information relating to supply of government floor by the floor mills and so, including copies of the sale register, challan, so. Compliance with the order dated demand passed by the said so, whatever information was available with the department and received from the concerned cooperative was duly furnished petitioner by letter. There was no deliberate or intentional withholding of the information. Thereafter, a compliance report dated Iman and an action taken report dated was submitted before the Iman, copies of which are enclosed herewith. And upon consideration of the submissions made by both the parties and the settled position, the Assam AIA observed that all the evidence has been furnished by the public and closed the matter on 19/7/2025.
Then my action taken report, my lord, there is an action taken report. In the letter, it was mentioned that that thereafter a compliance report.
Yes. All the whatever information they have.
Then page 34 is the compliance report, my lord. Page 34 stating that the cooperative societies are not bound to supply the information because of honorable court's order. They are not come under the purview of.
What is your prayer? Furnish complete information as sought for by the petitioner by application dated and as per the order dated 9/1/2025 passed by the State Chief Information Commissioner.
Yes, ma'am.
Now, your prayer, which is being the relief which has been sought for, is the information as well as it is further qualified by the order passed by the State Information Commission.
Yes, ma'am.
Now, the State Information Commissions, you have approached this court that in spite of the State Information Commission's order,
Yes.
they have not complied.
Yes.
That is your reason.
Yes, ma'am.
Now they have submitted a compliance report before the State Information Commission and the State Information Commission is satisfied and closed the proceedings. So therefore, can it be said that there is still non-compliance to the order dated 9/1/2025?
As by my understanding, my lord, the compliance report is page 34 in the petition I have annexed. In the second paragraph, they have stated that the millers are not bound to supply the information beyond 6 years. And the cooperative societies are also not bound to supply the information as per honorable court's order, because they are not come under the jurisdiction of the RTI Act. Page 49. In such event, my lord, the register of cooperative societies are required to furnish the information. If page 34 is the compliance report, that is not the compliance report.
11/4/2025. Where is the document?
Page 34.
In the writ petition.
And where is the order by which it has been accepted?
My lord, page 49 is the order passed by this honorable court.
No, 19/7. Ah, got it. In reference to the so-and-so and the enclosed report of the Deputy Commissioner Golaghat, I am directed by the Commission to inform you that upon consideration of the submission made by voter at the judgment of the alia in so-and-so, the order of the Iman and the fact that they are private and neither substantially financed nor controlled by the government, the Commission has observed the public authority has provided all available from therein. As such, no further are deemed necessary and the matter is hereby closed. So this is 19/7. 19/7, there has been a closure of the proceedings.
I have not received the 19/7. If the millers and the societies are not providing the proper information, then respondent number 6 and 7 are the appropriate authority, my lord. Register of Cooperative Societies.
What are the informations you are asking? Required from the floor mill supplying government floor to the cooperative society in Golaghat district, such as sale register copy, challan copy, information required from the floor mills supplying government floor of the cooperative society. This is the private information of the of the cooperative societies.
My lord, cooperative sector, it is supplied through the Register of Cooperative Societies. So Register of Cooperative Societies are made party in this writ petition. If millers and the cooperative societies are not obliged to furnish the information, then the information has to be come from the cooperative society register, respondent number 6 and 7. They have not replied to the writ petition, my lord. They have not filed any affidavit.
Now, who maintains the sale register copy?
Cooperative societies. Cooperative societies.
The cooperative society denies that they have anything to do. They are not, they would not come within the ambit of it. Does the register cooperative society maintain these documents?
Maybe, my lord, because my lord, through the
Maybe. Mr. Counsel, no maybe business.
my lord,
We
cooperative.
are at the stage when your basic prayer out here is that you have asked for certain information on 6/8/2023, and the State Information Commission have directed to provide the information. And that information thereafter has not been provided, so you are before this court.
Yes, my lord.
In the meantime, the State Information Commission, on the basis of the information which has been provided, on the basis of the action taken report as well as the other judgments,
Yes, my lord.
have come to opinion to the effect that there is sufficient compliance by a communication dated 19/7/2025 issued to you. That's it.
19/7/2025, that order is not with me.
It is marked to him only. I have a copy, but it is.
Show it to you.
Yes, yes.
Page number?
So therefore,
It is not with me.
so under such circumstances, your relief is there. Your relief which you have sought for has already been taken care of by the State Information Commission, saying that we are satisfied with the directions which we have passed in our order.
Yes.
Okay. Now, this satisfaction is not under challenge. One, be that as it may. My question therefore is as to whether there is a requirement of the Register of Cooperative Society to maintain these documents which you have mentioned in the communication dated 8/6/2023, because you categorically say that the informations be provided by the mills
Mills and cooperative societies.
and by the mills.
Yes, ma'am.
You see, kindly see, information required from the floor mills.
Floor mills.
So this information you are asking from the floor mills. The
Supplying
floor
gov-
mills are private companies. Okay.
Supplying government floor to the cooperative
Done it.
societies.
The floor mills have supplied it to the government. But the private floor mills would not come within the ambit of the RTI. The government may. If the government is required to maintain certain register, ask that. You have not asked that. Information required from the Golaghat district cooperative societies
Yes, ma'am.
regarding supply of government floor so and so, so and so, so and so.
Yes, ma'am.
Again, you are asking from the Golaghat district cooperative societies without mentioning how many societies are there.
Yes,
It is innumerable.
Our society.
Information required from the secretary of the Golaghat District Cooperative Societies Agent Association, such as certified copy of the lifting book. Difficult. Very difficult.
Since they have not supplied because of RTI, they are not bound to supply the information. My humble prayer would be
No,
that.
you have to ask the information from the government.
Yes, ma'am.
Whether government is required to maintain this. If you are sure that yes, these are the documents which have been issued by the government, they must be having copies of that. Ask those from the government. Therefore, you see 19.7. See the 19.7 which he has given you.
Yes, ma'am. I have not received, ma'am.
Yes.
Then I will consult with the client, my lord, regarding that compliance report. That is not with the writ petition. Or if you lordship,
No, that order has been passed.
or you lordship,
We need to close it today and giving you liberty
yes, ma'am.
to ask them if under the Right to Information Act to their respective area, to the Register of Society or those
Yes,
people
ma'am.
who have the
That
government.
number
people
6 and 7.
who heard Mr. So-and-so, the learned
Sir.
counsel appearing on behalf of the petitioner. Mr. D. Nath appears on behalf of the respondent numbers.
1, 3, 4, and 5.
And who appears for the others? Does it, is he a party?
6 and 7.
6 and 7, they are parties.
The present petition has been filed by the petitioner with a prayer that the petitioner be provided the information as sought for in the petitioner's application dated 8/6/2023 and as per the order dated 9/1/2025 passed by the State Chief Information Commissioner Assam. The information which was sought for by the petitioner on 8/6/2023, where are so and so A1, 2, and 3 to Didibo. It's 86 or 1, 2, and 3, and again Didibo. On 9/1/2025, where is that order?
My lord, page in the
On 9/1/2025,
page 60
the
and
Assam Information Commission
page 60 and 61.
the appeal petition of the petitioner was disposed of.
Before that, may I submit?
direction?
My lord, one page was missing, therefore additional affidavit was filed, page 61. 60 to 62.
Lordship, before that, page 28 comes. Well, some information has been provided to him by page 85.
It's okay.
Page 28, Lordship.
Page 60,
Ask an order.
page 61, last paragraph.
Directing what is the full form of SPIO?
State Public Information Officer.
State Public Information Officer as well as the Deputy Director FPD and CA, Golaghat, to furnish the appropriate reply to the petitioner in consonance with the provisions of the Right to Information Act 2005 within a period of 20 days from the date of receipt of the said order. It is the case of the petitioner that pursuant thereto, on 11/4/2025, the Deputy Director IC FPD and CA Golaghat issued a communication to the Secretary Assam Information Commission that letters were reissued to all concerned millers, reiterating the requirement to submit the requisite queries and supporting documents. It was further mentioned that in response to the said letters, the millers have not provided any documents, but have submitted a letter stating that as per the IT rules, they were not required to retain records for more than 6 years from the end of the relevant assessment year. Further to that, the Samabhai Samitis of the Golaghat districts informed that the cooperative societies do not fall under the purview of the Right to Information Act. And in that regard, referred to the judgment of this court dated 1st of April 2019. This action taken report, Mr. Dina, the learned counsel who appears on behalf of the learned senior government advocate, submitted that this action taken report, which was submitted on 11/4/2025, was duly accepted by the Assam Information Commission, and the petitioner was duly communicated. Petitioner was communicated by the communication dated 19/7/2025. The learned senior government advocate further submitted that in view of the compliance being accepted, the instant writ petition, nothing remains in the instant writ petition. The learned counsel appearing on behalf of the petitioner, however, submits but that the petitioner have not been provided with the information as sought for by the communication date, by the application dated 8/6/2023. This court have duly, this court in the previous segments of the present order have referred to the informations which have been sought for. The information so sought for were from the certain private flour mills as well as the cooperative societies. There was no information sought for from the various government departments who have issued the notice, issued the orders. Under such circumstances, in view of the acceptance of the state acceptance of the action taken report dated 11/4/2025 by the Assam Information Commission, nothing further remains in the instant proceedings to be proceeded with on the question of non-compliance to the order dated 19/1/2025 by the State Information Commission. Be it as it may, and accordingly, the instant petition stands closed. Liberty, however, is given to the petitioner to file appropriate applications under the liberty, however, is given to the court, to the petitioner, if so advised, to approach the authorities under the Right to Information Act 2005, seeking informations from the government departments, if so permissible. The instructions which have been placed before this court by Mr. Dina is kept on record and marked with the letter X.
My lord, we have filed our additional affidavit, my lord, bringing the award, refresh award passed by the Deputy Commissioner, District Commissioner. my lord. Perhaps it is on record. my lord. It was filed on 18 July. Award statement.
Yes, yes.
Fresh award has been passed. 19 নম্বরটা দিয়ে আমরা content 19 টা দিই। 19 20 21 এনকে সামনে না award statement is at
It has been forwarded to the Education Department for seeking the fund, my lord.
এটা আছে ওটা মাইনাস টিকিং অর্ডার 83 না হয় না টিকিং অর্ডারটা কি লাগে
এইটুক হেৰি আছে।
এটা না, এটা না, এটা না।
9 points. 20 and 21 are 9 points.
Awards have been passed.
Fresh award is passed. now.
Pass, my lord.
What is the direction?
Which one your lordship is taking 19 million?
What is the
Contempt-
direction?
My lord is taking up the contempt 19 million.
Are they not same judgment?
But there are two judgments.
1525, page 21, in contempt 19. Page 21.
What is the direction?
Yes, sir.
I'm
Page-
taking up which matter, 20
Contempt 20.
or 19, let us take 9.
19 million.
What has happened with this?
The its direction is at page 22, my lord, from paragraph 7 onwards.
Page 7.
Are directed to determine the compensation receivable by the petitioner for the land acquired by them and involved in so and so by applying the provisions of the demand and release to the petitioner their due expeditiously by adjusting again compensation. Be completed within a period of 3 months from the date of year. Okay. So pursuant thereto, you have now passed an award
My lord.
in terms with the new act.
New act.
Okay. Now the payment is to be made.
Lordship.
Second part.
Against that, there was a challenge before the division bench.
It was.
For
it
this
was-
case, not. For the other two matters, my lord,
Okay, what has happened to the division bench?
the upheld the order of the
Okay.
same.
Well, this is- Now, against this, you have made whom parties?
Is here it is, my lord, the
Now, awards have been passed,
pass, my lord. But
land taken.
land taken much back, oh, my lord.
Okay. Now, the money is to be provided by whom?
By the state, my lord. The respondent is, my lord, the
cannot do
revenue department.
They are not the authority, na, to make the payment. They will only make the
The
payment
higher-
if it is
higher
available
education-
by the requiring authority.
The higher education department.
If Lordship may be pleased to, I have got the instructions, my lord.
This, Dia said.
The authorities have already taken up the matter, my lord, before the higher education technical department. So that is the requiring authority, my lord.
Both of you are having same.
Yes, yes, I have given.
Why you are giving two copies the same thing? One council. Or it has a marking, put up and forwarded to the standing council for taking steps. Is that the reason why you are placing this one? Otherwise, there has to be a justification. One advocate puts the same document twice. Okay. Now, therefore, the question is, awards have been passed. Now, once the awards have been passed, now the question comes of payment.
Lordship.
And the quantum of compensation is to be determined in terms of the 2013 Act.
It has been done.
Which is inevitably followed in all land cases, land acquisition matters. Here also they will get it. Now the matter rests on the, my lord, disbursal of the money. And the requiring department here is, my lord, the higher education technical department. And the purpose for.
And you are not challenging the award.
No, not yet, madam. If you have to challenge, then you have to go for a reference, madam.
You have to now know that the moment you are filing the additional affidavit means you have knowledge.
My lord,
You need to file your 64 application if you are aggrieved. Keep it pending. That's a different thing.
my lord.
That is one aspect. But the other aspect is for payment. Payment is here. So later on, you may miss your bus.
No, well, that I, my lord, will take care of.
Even
I'm
if
obliged,
the- Even if the petitioner files appeal under 64, 73, my lord, then, my lord, there also, that matter can be agitated, my lord. The requiring
no.
authority, no, my lord, requiring authority can be roped in.
He will go under 64.
Yes.
For enhancement.
The moment he goes for 64, then an award will be passed.
That will
Once
be
an
a-
award is being passed by the reference court, then it can be looked into. But as of now, the petitioner says that you have taken my land.
Absolutely.
You have passed an award. You have not made the payment. The civil court or the reference court have no business out there now. It is now a proceedings under the writ.
Yes.
If you don't make the payment, there is a violation to the court's order.
So that is true, but my lord, the money has to be disbursed, my lord, by the requiring department. That is the difficulty. I can understand because, my lord, the scheme of the land acquisition act, my lord, law does not, my lord.
Correct with due respect to the coordinate bench, the court should have first kept the matter pending for passing of the award.
Award and that too, my lord, the requiring authority was
One
not.
is
a party
that, and the
respondent.
second is if there is the new act has not been applied with, then it's a question of reference.
The reference and most significantly, my lord, the requiring authority.
Anyway, let us not go to traverse to those details, taking into account that the matters to settle. Now tell us when you are getting the money.
This communication appears to have been.
Payment will be made by whom?
My lord, it is the higher education technical department. If for a moment, lordship may be pleased to take up the last page of the instructions, my lord. Last page of the instructions. That is a communication made on February itself, my lord. By
There are two persons who needs to be made part.
My lord.
One is the higher education, the other is the finance. First, you make the higher education.
Higher education is a party in the contempt case number 20 and 21.
Who is appearing?
perhaps notice.
Notice to serve, notice of.
Notice have not been issued.
Notice served on everyone.
Whether notice has been served.
We asked him. to
Lordship
do
may
it.
see the last orders, my lord. Lordship's order.
In contempt 20 and 21, my lord, he is a party.
Surveys upon respond number 1, 2, 3, 4, 5 have been presumed to be complete.
19 of 9.
So
Lordship's last order dated 15/6/26.
1, 2, 3, 4, and 5. 5 is who?
3, 4, 5, I am appearing. 3, 4, 5, I am appearing.
You are 1 and 2.
5 is the ADC by name, my lord.
Only for one.
5 is the ADC, my lord.
No, whom have you made the, who is the technical officer that the
Higher,
what do you call the higher
technical.
education officer?
1.
Respondent number 1 is the, sorry, my lord. Respondent number 1 is the technical department, my lord. Higher education technical department.
Now, the concerned person has been arrayed as a respondent, my lord, in item number 21 and 22.
Contempt 20.
Contempt 20
And
and,
20.
and 21. But in contempt number 19, that is item number, my lord, 20, my lord, that higher education personnel has not been arrayed as a party respondent.
My lord, why it was not arrayed as a party respondent? Because of the fact it was not a ground taken in the writ petitions or the writ appeal that the we have not arrayed any necessary party in the petitions, my lord. That is why the instructions was to state respondents, which has been already arrayed in the writ petition. It was not a ground taken by the state that the requiring department is someone else. Therefore, since the notification was issued by the revenue department, so all connected departments were taken as a party, my lord, in the writ petition and the writ appeal. Writ appeal was, of course, preferred by them. In writ proceeding,
Who has preferred the writ appeal?
the deputy commissioners, not the state.
Not the requiring authority.
Not the requiring authority, neither the state nor requiring authority, it is the deputy commissioner
Against,
against the single judge's order.
why?
They know, my lord. That too, without the approval of the government.
Well, ground,
Anyways,
ground
that's
taken
beside
was,
the point.
ground taken was
Now
that
therefore, you do,
the earlier act applies. That was the ground.
I bring it to the notice of this court, these communications.
Well,
And on the basis of that, you make it up, you make that secretary to the government of Assam Higher Education Technical Department as a party to the present proceedings.
in my lord, in contempt, my lord,
19.
or in contempt 19.
Okay.
In other two cases, it is already there.
Already there, other two cases. So therefore, in other two cases,
Who is appearing for response?
whether notice has been served, my lord. I-
Serve, it is already served. It is
then
recorded.
Somebody will have to appear, man.
It is already
On
recorded.
behalf of that incumbent officers.
Higher education to some.
So revenue authorities are duly represented and he is representing the collector and representing the additional chief secretary.
When was the award passed?
That was
February.
first
February 26.
February, yes.
February. Oh, February 2026.
And when have you asked the authority?
Well, on February itself, 11th of February.
11 to 26 more.
Hmm?
11th of February 2026. This is later our last communications.
None has appeared on behalf of. Well, okay. This court have duly taken note of. That in contempt case number 19/2016, the secretary to the government of Assam, Higher Education bracket Technical Department, is not made a party to the president, is not arrayed as a party. Dr. A. Samua, you are doctor. Dr. A. Samua, the learned counsel appearing on behalf of the petitioners, submit that the needful would be done by filing an appropriate application in contempt C 19/2016. However, it is relevant to take note of that in contempt C 20/2026 and contempt C 21/2026, service the secretary to the government of Assam Higher Education Technical Department have been arrayed as respondent number one. One, na?
Yes, well, one.
Standing Council of Higher Education, I can communicate that.
However, he has not put in appearance. This court therefore have requested Miss P.R. Mohanto, the learned standing counsel of the Higher Education Department, to duly intimate the said official that in future, if the said official do not appear in the instant proceedings through a counsel, the present proceedings, the instant proceedings shall proceed against the counsel, against the contemner ex parte. Mr. A. Samua, the learned counsel who appears on behalf of the petitioners in the contempt case number 20/2026 and contempt case number 21/2026, directed to furnish an extra copy in each of the contempt application to Ms. P.R. Mohanto, so that she may communicate the same to the secretary to the government of Assam Higher Education Technical Department. Next. This court further takes note of that in the meantime, pursuant to the orders, the judgment and orders passed by the learned coordinate benches, in WPC number 5730/2014, 6397/2014, awards have been passed by the learned deputy commissioner,
District Commissioner.
by the district commissioner, Kamrup Rural, by awarding the compensation in terms with the right to fair compensation number 2013. This court also takes note of that the district commissioner acts as an agent of the government while acquiring the land. But acquisition, so the payment of the compensation is dependent upon the requiring authority providing the funds. This court duly takes note of. A communication issued. Mr. Barpuzari, I won't take this one. It doesn't look nice, huh? Wherein it says put it up before the standing council.
It may be please to refer to the last page only, my.
It's okay. Duly takes note of the communication issued by the district commissioner,
Yes.
Kamrup Amingao, to the standing council of the Revenue and Disaster Management Department, which has been kept on record and marked with the letter X. From a perusal of the said document, it is apparently clear that the district commissioner, Kamrup Rural, have already intimated the secretary to the government of Assam Higher Education bracket Technical Department on 11/2/2026 for providing for immediate mobilization of the funds for release of the revised compensation amount within 2 weeks. Therefore, it is apparent that in view of the passing of the modified awards in terms with the Act of 2013 and steps so taken by the District Commissioner, Kamrup Rural, there is no prima facie there is no willful or deliberate violation or judgment and orders passed of the orders passed by the learned coordinate benches against which for compliance of which the present proceedings have been filed. It shall duly depend upon the Secretary to the Government of Assam, Higher Education bracket Technical Department to provide the necessary funds so that the petitioners could be can be disbursed the amount by the district commissioner. Therefore, puts to notice the respondent number the respondent number 1 in contempt case number 20/2026 and 21 contempt case number 21/2026 as to why proceedings should not be initiated for not releasing the funds to the district commissioner, Kamrup Rural. List this matter for an update. List this matter. Second of September 2026. In the meantime, madam, the name of Ms. P.R. Mohanto, the learned standing counsel of the Higher Education Department, be reflected in the cause list. In the meantime, you file that also.
Well, I'll do this one. I'm deeply obliged, madam.
In fact, this process should have been done at the time of writ petition.
Had they, my lord, added the requiring department, this could have been solved out by now, my lord.
Requiring department is there, 1 and 2. One is there in the other two, in the main writ petition. Means most probably in the main writ petition, that aspect might most probably have not been mentioned.
That was not mentioned.
That is why. Yes, what is this?
My lord, this petition is covered by my lordship's recent order, my lord. There is an order passed by the deputy commissioner, my lord. Impugn order is at page 30 regarding, my lord, cancelling my obligement, deeply obliged.
Itu na order to this. Where is forest or PHE? I'll help it. Last time I said that, and this time also done that. Hello, Rakhoksun. RR Gogoi has to be. This time I don't think I should recall that order. Last time I recalled it. But this time I'm not recalling. None appears on behalf of the petitioner as well as the respondent on call, for which the matter stands adjourned to be listed for 6 weeks.
Respect of item number 56, my lord. On behalf of Mr. K. Uddin, Learned Council engaged. So his father expired in the last week, my lord, sorry, last night, my lord. So he went to Korimgon, my lord. So matter may be accommodated on any day in the next week. My lord.
Let's see. We'll take care of it. Yes, what do you have to say?
Lordship, petitioner husband was died due to electrocution while he was engaged maintenance work of a 11 kV feeder.
You were engaged by some contractor.
Some contractor, agent.
Then
Lordship, in this case, Lordship, agent was engaged by the respondent authorities.
so what?
So as a principal,
No, the principal, all these things would not
Let's say-
apply. He has appointed, the APDCL has appointed them.
yes,
That MS Babul Roy,
yes,
and you were an employee of him.
yes.
So you claim your compensation from them also.
Yes, Lordship, there is no bar to read
Not
petition,
here.
Lordship. Lordship,
Not
because
in terms,
Lordship,
from
in
this,
similar,
unless you challenge this electrical accidents report in accordance with 162.
Yes, ma'am.
This court cannot hold them liable in terms with regulation 5.
Lordship, because similar situated cases, honorable court, our honorable court has allowed to, as per notification of their notification,
So-
they have allowed. We have annexed the judgment, Lordship,
Eh.
page 31, Lordship. Sukumar Brahmo case, Lordship. Page 44, Lordship. Paragraph 23. 23 and 24. Allowed to fix on 4 lakhs already allowed, Lordship. And same, another, in our High Court, another case, Lordship, Tara Bhanu. Honorable Court also allowed, Lordship, as per notification. So,
Let me come to page 37. it is reported in the report. Got it? After 7 lines.
Yes.
Report electricity inquiry that the victim came out of his residence to the spot hearing deafening sound and unknowingly came in contact with the snapped 11 kV bare conductor, which was lying in the ground and got the fatal electric shock. It was further reported that another person, namely, was also injured while he was saving. The report number 5, the respondent number 5 had observed in the inquiry report that a low voltage distribution line emanating from the distribution substation of the village were without statutory electrical protective and so and were not being maintained in the appropriate manner to ensure safety of so and so. According to the inquiry report, had appropriate safety preventive measures have been taken and had the regular and proper checking been done and so on. Contains findings of contravention of so and so, so and so, so and so. Here, this is the reason why it has been given. Don't apply judgment just for the sake of it. I have passed many orders where there are electrical accidents in the favor of the. Here you were appointed, go under section 9, not regulation, go, entitled to go before the civil court, not here. And in that case, the person was trying to charge his mobile.
Yes.
This has nothing to do out here.
Lordship, MC case, the strict liability is applicable in this case, Lordship.
What?
Strict liabilities applies in this case, Lordship, because principal, he is a principal, Lordship. So
It's not a question of principle. They were not at fault. You have worked out there, your husband had worked out there, having no knowledge about it. He has put himself in danger without having proper knowledge and acumen to do a particular thing. It is the absolute responsibility of that contractor who have done so. Okay.
Lordship, I've rely on the MC Mehta case, Lordship.
MC Mehta, you have to go to Supreme Court. Let me dismiss it now. Go to the division bench. The division bench, if it allows, is good. Otherwise, go to Supreme Court and rely on that.
Okay, 162.
Heard Mr. So-and-so, the learning
That
council.
observation may be given, Lordship, to 162. That observation may be given, Lordship.
You want to challenge 162?
Liberty may be given.
I give you the right to challenge 162, or even instead of challenging 162, you need to go under and file a civil suit. Better of that. Unnecessarily spending your time because you will get more money. Here you will get only 4 lakhs at best. I can't give you more than that because that is the liability which has been categorically mentioned to that effect. But in the civil court, you may get more money. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. B. Chaudhary appears on behalf of the APDCL. Ms. M. Borman appears on behalf of the respondent number 5. Present with petition has been filed by the petitioner. Aggrieved by the inaction on the part of the respondent numbers 1 to 4 in awarding due compensation to petitioner on account of the death of her husband due to electrocution. This court duly takes note of that in exercise of the powers under section 181(1), read with section 57(2) and 57(3) of the Electricity Act 2003, Assam Electricity Regulatory Commission have framed a regulation, mainly the AERC bracket compensation to victims of electrical accidents bracket close regulation 2019. Chapter 3 of the said regulation deals with, is with the heading compensation. Section 5 stipulates the liability for compensation. And Section 6 further stipulates as regards the quantum of compensation and makes a reference to Schedule B to the regulation. Section 5 and 6 being relevant are reproduced here in under. From a perusal of Section 5, it is apparent that the licensing company, that is the APDCL, the licensee oblique the generating company, that is the APDCL herein, would be liable to make payment of compensation if the electrical accident is attributable to the fault oblique negligence of the licensee oblique generating company oblique the CPP. In terms with Section 6 of the regulation, read with Schedule B, the compensation payable for the loss of the human life as a result of electrical accident is rupees 4 lakhs per person. The question arises in the instant proceedings is to whether, in exercise of the powers under Article 2 to 6 of the Constitution, this court can direct payment of the compensation in terms with Section 5, read with Section 6 of the regulation. This court duly takes note of that in various judgments passed by this court, compensation in terms with Section 5 and 6, read with 6 of the regulation, have been awarded when it is clear from the materials on record that the accident, electrical accident, is attributable to the fault oblique negligence of the licensee oblique generating company or oblique the CPP. One of the most important materials which is being taken into consideration, as would be seen from a perusal of the various judgments passed by this court, is the electrical accident report submitted by the electrical inspector. In the instant case, the respondent number 5 has filed an affidavit in opposition enclosing the electrical accident report, wherein the fault, wherein no fault have been attributed to the APDCL. Rather, the fault has been attributed to the employer of the petitioner's husband, one MS Babul Roy, for permitting a personnel who does not have adequate acumen, who does not have adequate
Precautions. Page 52, perhaps, one.
Page
Contravention number 4.
personnel who does not have a workman permit, electrical workman permit, and being not a designated and a competent person to carry out electrical works on high voltage installations. First, this court also takes note of that there is, as on date, there is no challenge to the said electrical accident report dated
20th Jan, 22nd.
22/6/2026. Under such circumstances, it is therefore the opinion of this court, as no fault can be attributable on the basis of the electrical accident report upon the respondent number, upon the petition. This court, in exercise of the powers under Article 2 to 6 of the Constitution, cannot award compensation in terms with Section 5 and 6 of the regulations. Accordingly, this court does not find any merit in the present proceedings, for which the writ petition stands dismissed. Before parting with the record, this court makes it very clear that this court had not exercised its jurisdiction under Article 2 to 6 of the Constitution in the present proceedings on account of the electrical accident report. In the circumstance, the electrical accident report is challenged and the petitioner approaches the civil court, competent court of civil jurisdiction. The present judgment shall not prejudice the petitioner.
May I please observe? On instruction of my petitioner, Your Lordship, so the matter may be withdrawn, Your Lordship.
Mr.
Yes, Islam, Your Lordship.
Name,
Yes, Islam.
Mr. M.
No,
S. Islam.
Yes, Islam, yes. Lordship.
The learned counsel appearing on behalf of the petitioner submits that he has been instructed by the petitioner to withdraw the instant writ petition. Taking into account the above, the instant writ petition therefore stands closed on withdrawal. Ms. A. Gayan appears on behalf of the respondents. Respondent Union of India. And let's CGC appears on behalf of this.
Highly obliged.
What is your instruction? Are the petitioner in possession?
They are not in possession. It is the report of the one. He is not in possession. Lordship,
Where's the
along with this
report?
instruction, the circle officer's report is also there.
This the circular officer is wrong.
Probably
Because in view of 14.3,
14.3 is different and 14.4 is a special provision. If your lordship takes up 14,
14.4 makes it apparent, means You see, prior to 2001, there was a declaration given by the government pursuant to that people who were in possession prior to 2001 would be granted settlement. That is the landlords. And therefore, post that it would not apply. So that was automatic. But here, this is not a case of an automatic thing. How do you take care of 14.3?
14.3 says, my lord, if you also picks up 14.3, the state government will not consider settlement of any government land in Gauhati city or any other town area under possession of individual or other persons merely on the ground of, this is merely on the ground of, only
Yes.
possession will not
So
confer.
therefore, you cannot say, are you therefore encouraging those people who are
No.
to encroach upon the government land?
Only possession, there will be encroacher.
No, Mr. You see, it is only in view of the, kindly see 14.4, read it.
Yes,
However, in view of the land policy of 1989
yes.
and other government decisions prior to
And
the adoption of the
adoption
land
of this
policy, the
policy.
case of indigenous land if found eligible and who have been under continuous occupation of government land since or prior to so and so may be considered for settlement under so and so, so and so, so and so. So that means there are two things. 14.3 makes it very clear that there is no that merely because you are in possession, you don't have a right.
You have to fulfill the other criteria. also.
Other criteria.
Yes.
And so therefore, if we go by 14, it is only in respect of 14.4. 14.4 is an exception to the possession of the land. Because otherwise, if we hold that you need to be in possession of the land, then only you'll be opening up that all government lands will be evicted.
That is not the
encroached upon.
object, my lord. If we see the normal procedure also, then normally the land is allotted first. Then even allotted for cultivation or whatever. Then after 3 years, if they're still doing the same, cultivating their land, then only it will be settled. So here, although it was allotted, but the allotment orders were not issued. So it comes under the urban homestead land. Urban homestead land, since it was prior to 19 policy, so that exception comes, my lord, 14.4. So to apply 14.4, they have to have the possession of the land. That is my submission, ma'am.
Later on, don't tell me that there has been lot of encroachment on this basis. If it is your submission to that effect that one has to encroach upon government land, and then only the land would be handed over.
No, that is not the policy.
Or is it your case that only persons who have been there from 2000 prior to 2001, they would be granted settlement, not others? That is also not the question.
That is also not the case. Prior to coming of this policy, my lord, this is the special provision.
How will the special provision apply in this regard? My question is,
because that was approved prior to coming of this policy.
Understood. See, therefore, if a person is in possession of the land prior to 28th of June 2001, in view of the land policy of 1989 and the subsequent decision, he need not have further criteria to be fulfilled.
No, landless and other criteria as per.
Except that he is an indigenous person.
Landless.
Landless indigenous. It will be done. But in respect to the others, then also a person may not be in possession. A person may be all along residing in a tenanted place. Are you saying that he is not entitled to
apply, my lord?
At all
apply, but not that particular plot, because
you are not to. It is not that you can. He is required to be granted the settlement in respect to that plot. No,
that is not
saying that. So therefore, 14.3 also makes it very clear. So he may not be granted allotment in respect to that particular plot. But his allotment application can be considered
Yes,
for some other land.
for any other land, government land.
Therefore, you cannot reject this application. He may ask for. That's a different thing. He may ask for. But that doesn't mean that he needs to get it. Here there is an approval also granted.
Approval is that.
Once the approval is granted, then it is outside your purview. It's the revenue department.
It was referred to revenue department as.
So why is the circle officer putting up all these things? The revenue department who has to place it. Why it has not been granted? Is the deputy commissioner in the STLEC meeting has been approved.
Approved.
Then why
Now
it has
it
not
wa-
been granted? This was approved as far back as in the year 2005, 15. Then they have gone into the extent of going for the land valuation, everything.
Those were done.
Then
Only the allotment letters were not
therefore
issued.
request you to kindly take steps for according approval for settlement of the land. This is being also given by the deputy commissioner to the commissioner and secretary. Why haven't you
And
given?
they replied to it that the deputy commissioner is the competent authority.
Then why are you not giving?
Well, but
Your deputy commissioner in 2016 categorically mentions that look here, she is entitled, so kindly grant it. SDLSA permission has been granted. Why
But
you are
that-
not granting it? And why is the circle officer sitting over it? It's a very serious thing.
the report was called from the circle officer.
No. We don't require the circle officer to come into the picture. Why you have not granted the settlement?
And my lord, page 30 is from the joint secretary. my lord. At page 30. Page 30, my lord, that is also been issued by the joint secretary to the DC. my lord.
Then why you are adopting certain other, you are adopting a the allotment, everything has been done. Now you are adopting the land policy of 2019.
That may not be correct. Land
Then-
policy is for the,
This is a serious thing which has been done by the deputy commissioner. This court have sought for instructions on 27/11/2024. However, no instructions in that regard was produced on 13/7/2026. And accordingly, the writ petition was directed to be listed today. Today, when the matter is being taken up, Mr. B.J. Talukdar, the learned senior counsel, assisted by so-and-so, submits that some more time is required for providing information in view of the current flood situation. This court is cognizant of the fact that there is a flood situation. However, this court finds it very relevant to observe that for the last more than almost 2 years, instructions have not been placed. It shocks and surprises this court. This court is shocked and surprised at the submissions so made by Mr. B.J. Talukdar, the learned senior counsel, appearing on behalf of the deputy commissioner as well as the circle officer, whereby clause 14.4 of the Assam land policy of 2019 has been referred to. That too when in the year 2015 itself, the SDLEC had duly approved the petitioner's proposal. And thereupon, the Deputy Commissioner itself, in the year 2015, had forwarded to the Commissioner and Secretary Revenue Department for according the permission. This court also takes note of the document dated 16/6/2016 issued by the Joint Secretary to the Government of Assam Revenue and Disaster Management Department thereby informing the Deputy Commissioner that the Deputy Commissioner of the district is competent authority for allotment of the settled land to their indigenous landless person in rural areas. Under such circumstances, after a passage of 10 years, to question as to whether the petitioner, to question the legitimacy of the approval on the ground that the petitioner does not fulfill in terms with clause 14.4 of the Assam Land Policy 2019 appears to be a malicious act on the part of on both the district commissioner, Jorhat, as well as the circle officer, concerned circle officer. Under such circumstances, the district commissioner, Jorhat, is directed to explain why, even after the communication issued by the Deputy Commissioner Jorhat on 23/5/2016 and the communication which has been issued by the Revenue Department to the Deputy Commissioner Jorhat on 16/6/2016, the petitioner have not been granted the allotment.
Letters. Allotment was approved, but letters were not issued. Allotment certificate.
Allotment letter has not been issued. List this matter again on 17th of August 2026. And taking into account that the matter has been heard at length, the matter be shown as part heard. Else you won't get it. Aspect be brought on record by filing an affidavit on or before 14th of August 2026.
Your Lordship, my paternal land has established the Lokhiganj outpost, my lord. I pray for compensation, my lord.
What is the matter about?
In this regard, my lord, this honorable court passed an order 27/8/2024. Our observation is there, my lord. My pray for compensation. This is my paternal land. There is no dispute in the paternal land.
And then what happened?
I am waiting.
An affidavit isn't fine in regard by the
I
respondent
filed the
number
reply
4.
also, my
It says that the fact is, my lord, the same dog has been made a government khas dog. Later on, it has been rectified, which came to knowledge through the affidavit in reply filed by them, my lord. Moreover, my lord, though a circle officer is the best person to file an affidavit in this regard, my lord. Here, affidavit has not been in the record, my lord. It's not been filed. We got an, my lord, the communication, or it says, my lord, the land measuring 1 bigha 13 lessa covered by doc number 391 with regard to the disputed land, my lord. Patta number is recorded in the name of Zakirul Islam, son of Asam, and in the remarks column, it's a Lokhiganj police was put and a case number 19/2021. There is a police outpost from the 1967. They have till 2010, they have did nothing. The said police outpost was standing on that land, my lord. In 2010, they wake up and they file in, my lord, a representation.
Forget about representation or no representation. Is it 50 years?
More than, my lord.
In 2010, is it 50 years? No. You are claiming adverse possession.
No, my lord, no.
So then you recognize the right of the petitioners.
No, my lord, but SP's SP's affidavit says something different. It says that the land is a government khas land.
SP cannot say that.
I understand, my lord.
Can be said only by the revenue authority.
Revenue, circle.
Revenue authorities clearly mentioned that this land is the land of them. So when are you vacating?
Let me put this into record by an affidavit.
No, when are you vacating? This matter should have been finished in the year 2024 itself. We are in 2026. This doesn't look nice. Like the earlier matter. When a detailed order is being passed, thereupon the matter has been adjourned, nothing happens. And you are the main person responsible for adjourning it. See?
My lord, let me put through an affidavit, my lord. The circle officers, my lord, affidavit is.
My lord, my reply already is all, my lord, documents is annexed.
But why are you taking time so much?
Problem is there.
Whenever the matter has been listed, you have been taking time.
My lord, prayer is something different. They need a compensation for using the land, my lord.
Obviously, that you will pay.
Compensation, my
Apart
lord.
from that, you will pay the use of the land from 1967, you have admitted.
No,
The date of vacating, you pay
my lord,
on
that is
the
not admitted, my lord. The fact is different, my lord. The land was government khas land. Later on, it has been rectified as in my lord, patta land, my lord. It says
It's
so, my lord.
patta now. It is patta now.
Let me put through an affidavit, my lord.
It's a
Let us see.
patta. Next week. Put
Yes,
the
yes.
affidavit. Where, which place?
Bilasipara, Dhubri.
No, no water.
No
No
water, no.
floods.
10 days, my lord. 10 days, my lord.
No, no. Oh, for you. Comment, I don't give you time. This type of matter. But ask the circle officer to be present.
No, no, I'll get the affidavit. I'll get the affidavit.
His court, almost 2 years back, has specifically directed the respondent authorities, more particularly the state respondents, to bring on record the stand wherein then as to whether the Lockhegan's police watch post is situated over the land at measuring 1 bigha 13 lectures covered by dag number 391 or patta number 262 of village Lockhegan's under Bilasipara Revenue Circle in the district of Dhubri. The District Commissioner Dhubri, as well as the Circle Officer Bilasipara Revenue Circle, are the revenue authorities who ought to have brought the said aspect on record by filing the affidavit. Till date, the District Commissioner Dhubri, as well as the Circle Officer Bilasipara Revenue Circle, have not filed the affidavits. The conduct of the said offices clearly undermines the orders so passed by this court on 27/8/2024. Mr. Endas, the learned counsel who appears on behalf of the various respondents, including the respondent number 5 and 6, submits a final opportunity should be granted to them to bring on record their stand by filing the affidavits.
At least 10 days, madam.
This matter on 12th of August 2026. The affidavit be filed on or before 11th of August 2026 by the respondent number 5/6, respondent number 6. It is observed that if the affidavit is not filed, this court shall pass appropriate directions taking the personal appearance of the district commissioner, Dhubri.
My lord,
Affidavit filed to the circle officer, my lord.
What?
It definitely filed to the circle officer.
You file whoever, therefore I put an oblique.
my lord, pardon.
No pardon. This is not a matter of pardon. What is this?
My lord, repeatedly, my lord, they given time to file affidavit and they on their prayers. My lord, the last occasion, lordship will see the order ticket 1/6 and prior to that, my lord, 25/7/5.
What order did they pass?
My lord, the additional affidavit as per the lordship order, I have filed, my lord, the execution case and the, my lord, the decree, judgment and decree of the title suit along with the map. So on that.
Where is my order?
That was, my lord.
Come on, so what I see is, yes, substantial progress thereupon has not been made in many cases. Let me therefore see for my order.
My lord, the gross injustice, that is why we
The
your lordship.
owner of a plot of land at measuring is that in the name. Oh, yes, I remember.
Yes, my lord.
That is nearby to that particular thing, na?
Yes, my lord.
Okay. Is the opinion that if the petitioner was handed over the land in pursuance to the decree of the court, the boundaries of the land would be definitely mentioned in the decree.
Yes.
However, neither the decree passed by the court is on record, nor the revenue map showing the land of the petitioner. Under sir, without proper materials being brought on record, disputed questions of fact, that he may be granted leave to file additional affidavit bringing on record the decree as well as the revenue map of the land. Yes, now
I,
what
I have,
affidavit?
I have filed one additional affidavit that is on, my lord, the 16/3. Then, my lord, they seek time for filing the reply on this, my lord.
Filed by the, now, you
Yes.
have not, where's the decree?
Decree is, my lord, lordship will come at page. This is first, my lord, annexure A, page 73, my lord.
Decree, not. Land measuring 2 bighas. Which land has been decreed?
My lord, both the lands, my lord, two ducks, my lord, two
Main
schedules were there.
pursuit for specific performance of the contract compelling the defendant to sell the land, property of the scheduled delivery of vacant and khas possession of so and so. Specific performance of the sale of the suit land to the directing the defendants to execute the registered sale deed only and to register under law and thereafter for delivery of possession of the suit land to the player within 3 months. So there is a suit for specific performance.
Yes, my lord, there is a decree that is, my lord, page number
Now, this
78.
is an ex parte decree.
That is ex parte decree, my lord.
So once the ex parte decree has been passed
Yes, my lord.
against them, so there has been a possession handed over.
Yes, that has been by bailiff, my lord, that was handed over. Lordship will-
Now the decree says 2 bighas. Which land is the suit land?
Suit land is the both my together, my lord. Now this is two, now
How can it
together,
be?
my lord. Total land, my lord. Actually, there is a two ducks. So
Which is the suit land?
suit land is, there were my
Scale
two
of the
ducks.
suit land. These officers, they don't write what is the suit land.
There are two schedule, my lord. The one schedule A and schedule B.
No, but where is it mentioned? Where do I find that is the suit land? Schedule A is the suit land or the schedule B?
Lordship will
And
come.
why the schedule A?
Annexure B.
No, Mr. Mohanto, tell me why schedule A does not have a boundary?
My lord, that land, my lord, kindly come to my lord. This is,
I think schedule A is the total land. I think schedule B is the suit land.
my lord, this is 5 bigha and 2 bigha. Both are, my lord, the land together, my lord.
Then why schedule A doesn't have a boundary?
My lord, my lord, the total boundary is shown is there, my lord.
Huh?
Total boundary is total. Both schedule, my lord, kindly come.
No, schedule A, why it doesn't have 4 corners?
No, my lord, kindly come to my lord.
I've looked into it.
Annexure B, my lord.
I've looked into it. Where it says?
Both the schedule land, my lord, kindly bottom, my lord.
Where is it delivered? The mention of the under mentioned land.
Yes, well, now the boundary is shown as a north, south, and my lord, sir, there.
So schedule A does not have boundaries.
No, My lord,
What are the four corners of the area?
Schedule A and B, my lord, they were combined, then later on,
Schedule
my lord.
A is, wait, schedule A is 5 bigas,
Five
one
bighas.
katha land out of the land measuring
Same,
8
same.
bigas under Dag number 145 covered under 45.
Yes, my same dark, same.
Schedule B is Dag number 145 of PP number year.
Yes, ma'am.
Both the lands are in a compact plot and bounded. So both the lands are bounded by together.
Compact, my lord.
So on the north, there is a national highway.
Yes, my lord.
Now let us see 145. Where is the national highway?
National highway, my lord.
Come
This
to
is
Annexa C. Where is national highway?
National highway is, well, it will lot will get, my lord, in the west, this is, my lord, east, northern side of this, about this.
Huh?
National highway is the northern side of this map, my lord, Annex C.
National highway. That
Yes.
means where is the national highway? Is it a part of 152
No,
or
national,
145?
national highways come on the northern side, my lord.
Monto.
My lord.
It's 152, 132. What is the dark number of the national highway?
That is,
South is government land. South will be government land, which means there is nothing mentioned out here in the trace map. East is the village Pakka road and government land. East is where? And west is the daily market. Where is the daily market?
Daily market, my lord, this is dark is not, I think it is only once,
Because you see,
86, my lord.
132.
My lord, the dispute is, my lord, so far the dispute is there. My lord, they are claiming that they are getting the construction in the dark number 182, my lord. This is kindly come to, my lord, page number 85. 85, my lord.
85.
They are saying this is the government land and this construction is only confined to the government land.
Which
Not
land?
except. It is 85, 185, my lordship.
Where is
Dark number?
185?
182.
185, lord. This is my lord. I have,
Page 85.
yes, page 85. my lord.
It's only 182.
Yes, 182, sorry, my lord. 185
They are
is my land.
constructing there.
Yes, my lord.
And where is dark number 145?
145, my lord, this is 145 is, this is A, this is first one. If lordship will conjoin the both the map, lordship will get these things, my lord, clear.
Yeah.
This is the, my lord, picture of this land, my lord.
Here there is no 182 nearby.
My lord,
145.
My lord, kindly see, my lord, the first one is the 180, 145. This is my land. And the bottom, my lord, this is a 100. So this boundary and this boundary is, my lord, is touching my land. Where the 182 is finished, my lord, in the northern
So
side.
therefore, here if we see the south, now kindly see the boundary of your land which has been decreed. Kindly see that.
Yes,
South.
yes,
South is government land.
yes, my lord.
So
This is-
therefore, dark number 182
This is
is
the
the
government
government land. So your land is here, somewhere here.
This is my
In
185.
Page 182,
145
page
is my land.
84, because you see 145 dark number contains 8 bigas,
And my lord, actually, yes, 8 bighas, my lord.
out of which 5 bigas is being 5 bigas, 1 katha 10 lecha, and 2 bigas are there. Means 7 bigas, 1 katha 10 lechas have been there. So somewhere down the line, another 3 katha 10 lechas is outside.
This is, my lord, this land, it is a continuing, I have difficult to show, my lord. This land is continuing, there is after the national highway, again, my lord, land is started. After this is national highway, the again land was started, the same land, 1 bigger land is fall in that area. And this is, my lord, the corporate land, 7 bigger, 1 kata 10 less, my lord, this is. So I am giving the map, my lord, so that lordship can easily, my lord, recognize these things, my lord.
Now you are giving both the maps together and into one map.
Yes,
No?
sir. Yes,
So
ma'am.
therefore you show that 145, the southern boundary of 145 is the 182. You are meaning to say that?
Yes, my lord. And they are saying that they are only confined to 182, they are not encroaching that. But my submission is that they have already encroached my entire land. So let them file, my lord, any affidavit, and after that, lordship will decide, my lord. The commission may be appointed, my lord, because commission will very clearly it will be so. And now the
No, no. Why should we appoint? Go before the civil court.
No, my lord, civil court, my lord, is not there because his lordship, my lord, you are aware, my lord. My lord, in the Himachal case, my lord, lordship, my lord, Sandrasud already decided in the under 3 categories, my lord, where the, my lord, alternative remedy might be there, but this writ petition has the power because if the fundamental right is violated or any, my lord, the palpably national justice is violated or, my lord, this something is the excessive jurisdiction. So here, my lord, 2 things that they have done. Because the natural justice is violated without issuing any notice, they have encroached my land first. Second, my lord, they have excessive jurisdiction because this is my patta land. They cannot encroach, my lord, by any means. And after this long gap now, that cannot be decided. It's a very clear case, my lord. Nothing is there hiding. There, my lord, whatever they have submitted affidavit is a total false affidavit. This is my humble submission before lordship. For that, your lordship has the ample power to take a drastic action. Because they are every time they are saying they are not encroaching, but this is already encroached, my lord. And photographs also, whatever I am showing, it is also very clear. It is very clear, my lord. Nothing, any, my lord, infirmity will be there.
No, our stand is very clear. Page 51, my lord, para 3. It says that the construction took place in the government dock, my lord.
So that will be observed, my lord.
We have denied, my lord.
If something is, my lord, revealed, then action, they have to face the consequences for that.
My lord, it's through an affidavit, my lord. It's through an affidavit that stand has been brought, my lord.
In fact, my lord, in our affidavit, we have taken a stand that he encroached upon the government land. He was evicted by the deputy commissioner.
It is a different.
Thereafter, he encroached upon that land, my lord, and constructed, this was an agricultural land, and he has constructed some ice factory over there.
My lord, again, they are submitting the false submission before lordship. I was never encroaching any government land. This is my Miyadi Patta land.
Mr. Mahanta, you are also making that same, they can also use.
No,
your
then-
words.
then
No,
my-
no, Mr. Mahanta, they can also use the words you are using. They can very well say that Mr. Mahanta is also making false submissions.
Then I am ready to face, my lord. I am ready to face. I am ready to face, my lord. Whatever your lordship will pass. Because whatever they have submitted the government land, this is not the actual facts. My lord, there is this is land, this is same land, this is a Bautoli. So as per the, my lord, provisions, without, my lord, taking NOC, I cannot construct any construction over there. So I have constructed one ice factory and other, my lord, warehouses over there. So they brought these things that I have constructed without obtaining an NOC, man. On that issue, my lord, once this writ petition was filed, ultimately, although there was a stay order, but finally, that was, my lord, against my favor. They said that no, without issuing the NOC, that you cannot be constructed. That construction was demolished, my lord. Whatever they are submitting the government land, this is not totally false. This is my Miyadi Patta land. Only my fault was that without obtaining.
But tell me. As on date,
Yes, my lord.
are you in possession of how much land?
That this was my land, 7 bigha, that 8 bigha, 1 kata 10 lesa. 8 bigha, 1 kata 10 lesa.
No, you don't have 8 bigha, 1 katha 10 lesa.
Total land was 8 bigha. Now only
No, you have 7 bighas, 1 katha 10 lesa.
yes, my lord. This is this by way of this code.
So how much possession you are in?
Now, right now, hardly, my lord, probably 2 or 3 kata might be in my possession.
What?
Yes. They have already taken all. Hardly. This is my humble submission, your lordship. They have taken entire land.
There is some boundary out there. Just found out how much tag number 145 has now.
And that is why, my lord, I have played another thing also in earlier occasion.
Not necessary.
No, one thing, my lord.
Not necessary. Let us see how much tag 145 has and place it, and who is in possession. Let them give a report.
Yes, my lord.
Because your tag is 145. The circle officer can very well give a report as to who. Tag number 145 is the decretal land. You have been granted the possession by the decree of the court. 145, you were decreed a plot of land at measuring 7 bighas, 10 less. 7 bighas, 1 katha 10 lecha. In dark number 145. Dark number 145, what is the total land?
This is 7 bigha, 1 kata 10 less.
It can't be. Then you go against your own decree. Your decree categorically mentions that first plot is 5 bigha, 1 katha 10 lecha out of 8 bighas.
Yes.
Yes.
Don't you mention that? The second plot is 2 bighas. Out of both are dark number 145 or PP patta number so and so. Understood? So therefore, your southern boundary touches 182.
Total compact land, my lord.
Understood?
Yes, ma'am.
The southern boundary touches 182 because your boundary has a government land on the south. So therefore, your land is L pattern.
Yes, this is
Now, how much is the total land of Dag number 145?
145, my lord, a huge land. Another land also there in 145 in that area.
How much?
Probably, my lord, more than 100 bighas of land. Probably, my lord. I am not clear, but I will bring the instruction, my lord. And the land revenue authority are also able to show how much land is there. Because now the step by step, many government land, that 145, some land was government. So that land has been allotted to the different persons, my lord. Even college and so allotted some portion of land.
Only come to page 22. Mr. Jomabandi. What is your name? Darud Sultan. Total land is
Yeah, it is showing, my lord, 21.
3.80 978 hectares. Total land is Mr. Monto, you should prepare your matter and come before this court. Don't say that just for the sake of 100 bighas.
No,
It
no.
is 28 bighas.
28 bighas, but out of.
No, Mr. Monto, you are not ready.
No, no, my lord, I am.
This is the matter before any other court.
No, my lord.
I should not take
No,
up
no, I am.
this type
I-
of. No, sorry.
No, my lord, this is
I
not.
thought of
No, no, my
helping
lord,
you
this is.
out. No, Mr. Monto, don't come up and just make the submissions just for the sake of it. You have made a submission out here categorically 145 contains so and so.
No,
I
my-
have to show it to you that it has only 28 bighas.
No, but it is more
No.
than my land, my lord.
This is the matter before any other court.
No, my lord, kindly, my lord.
Sorry, other court will do it.
My lord,
We'll
only.
find out whether
My
you
lord,
get
only
an
one
order or not.
submission, my lord. This is very.
No, for Mr. Mohanto, you should be ready with your matter.
My lord,
You are not ready. You don't make, you just make the submissions just out of
But
the
a
cuff.
small submission, my lord.
No, there's no, why have you mentioned this man?
I'm sorry, my lord. I was miss, my lord.
No,
No, this is my extremely sorry, my lord. My lord, this is extremely sorry, my lord. My lord,
Okay, leave the matter another date. We'll have it another date. And then properly prepare the matter. Leave the matter on 19th of August 2000. In the meantime, prepare your matter properly.
my lord, I'll come to.
But a report was called for on the last occasion. This is regarding, my lord, the missing names of the petitioners from the revenue records, though they are, there was a settlement made in the name of this petitioners in 1996. Thereafter, accordingly, revenue records were corrected. From 2009 onwards, my lord, their names have been deleted from the revenue records, and no further land revenue was accepted. They are still in possession, my lord, with a house over the last 30 years, my lord.
How many petitioners are here?
My lord, two, husband and wife.
What's the name?
My lord, Nogendranath Chakraborty and Dipali Chakraborty.
They are Nogendranath Chakraborty
and Dipali Chakraborty.
This is in respect to Dag number?
My lord, the original settled Dag number was 643. Then when the Zamabandi was corrected in our name, my lord, it was shown as new Dag number 1883 of Patta number 568. Then it has been, my lord, I think further reclassified according to them as 1174, 1169.
Father's name is what? Jagannath Chakraborty.
Jagannath Chakraborty,
You submitted certain representations.
my lord.
What is your representation? Settlement of land
Not
measuring one
settlement, my
patta.
lord. The representation is regarding, my lord, deletion of the names from the revenue record and non-acceptance of therefore land revenue.
No, no. You see what has happened. Show me your title.
My lord, the title,
Sorkari land was given to Sorkari land of
my lord,
one
annexer
dag
1,
number
page 11,
643.
643.
Tata 10 lectures. Then
Then, my lord, the challan was paid at
you have
annexer
made
2,
the payment.
payment of rupees
After
60,000.
making payment,
Then, my lord, annexer 3, ending over of possession was directed to the settlement officer.
annexer 3 of dag number 643.
643.
643 means this still remains as a government dag.
My lord,
643 was a government dag.
government dag because it was sealing surplus.
Okay,
my lord.
now after that, after 643 it has become, you now have a new dag number.
My lord. Now, when the
1883 of patta number is 568.
560,
Okay. Now this is already there in the Jamabandi,
my lord,
which is there in the Jamabandi. This is mentioned
page
as
16,
patta
my lord,
number.
page-
So it is a new patta. Only your name is there.
yes, my lord.
So there is a separate patta issued to you along with a corresponding dag 1883. Now what has happened?
Now, thereafter, my lord, in the year 2009, my lord, further land revenue was not accepted from us, saying that our names do not figure in the revenue record. So there's
What happened to the patta then?
we don't know, my lord. Now it has been reclassified as some other dag in some other patta in
No, no.
which some other names are there. Because what the report, my lord, essentially says in the previous affidavit also, my lord, the same thing was filed. What has been presented today, my lord, I just had a glimpse. It has been shown that 17, it has now become 1779.
Now his patta number is what? Why you are bringing Bondupadhyay's people's name?
Because, my lord,
And Jyotindra Nayan Dev,
yes, my lord.
they are dag number 642.
Yes, in fact, the affidavit earlier file also says so, from 642, my lord, old. 1179 was carved out, my lord.
43 new ducks.
What is this document? This document shows that the area is 18.29 lectures.
Number 1, yes, my lord. 18.29 lessons.
Because this particular document, we have been receiving the Khazna also. Where is patta number 548? Find out where is patta number 548.
548.
Because it happened in the recent settlement operation.
My lord.
Earlier, where you granted this land, 96.
96.
So 96, so in this recent settlement operation, find it out from that particular land, superimpose it over that particular land and where it is. We'll be having a map, I suppose.
Yes, madam.
Produce the trace map pertaining to 548, 568, patta number 568. And the corresponding it on the next date. This type of instruction won't help you. Blood,
No, madam.
not in Gauhati,
Hello, what is Zonali?
not in Sipsagar.
No.
No, no, madam. It's not only, madam.
The circle officer, Dispute Revenue Circle is directed to place before this court the trace map of patta number 568. Trace map of the patta number 568. Of village Zaporigo under Beltola Moja, which existed prior to the settlement operation of Dag number 11. What is that? 183
183.
of patta number 568 of village Zaporigo under Beltola Moja, which existed prior to the settlement operation, and the change and the corresponding trace map of the said land post the settlement operation on the next date. This is the matter on 24th of February, August 2026. What is
Lord,
this?
The petitioner's mother, my lord, while going to church in a Sunday morning to offer her Sunday prayers, my lord, she met with an accident and she succumbed to her injuries, my lord. And my lord,
Where is your FIR?
FIR, my lord, you will find at page 24.
The vehicle is identified.
Vehicle identified, my lord, that is the issue, my lord.
So you can't get
But-
the compensation.
Yes, my lord, but one aspect is there, my lord. Because MSCT, I think I have to take instruction, my lord, that whether this amount was taken into consideration while computing the amount, my lord, in the MSCT court, my lord. Because under,
Which amount?
my lord, the amount that is ex gratia amount, my lord.
Why will it be taken into consideration?
Because, my lord,
Did you receive that amount?
not received, my
Then
lord, that is,
why will it be taken into consideration?
my lordship.
That is why you are the corresponding, there is another requisition along with it now that has been withdrawn.
Withdrawn, my lord, withdrawn,
So you are withdrawing or dismissing it?
my lordship. Because, my lord, in May 2026, my lord, a Supreme Court judgment has come, my lord, but that is, I think it will be in a different line, but in that particular case, my lord, the appellant, they took mediclaim and they honor, yes, my lord,
Medical is different.
my lordship.
Here the Supreme Court, the coordinate bench has said that when this particular ex-gratia is only payable when the vehicle is not identified.
That is, my lord, a notification 2023, my lord, the our state government notification. But this particular case, my lord, she expired in the year 2021. So 14 notification will govern my case,
Same in 14 notification that is being mentioned.
my lordship.
এই নামটো কি আছিল এই কেছটো? What is the name of that case?
Monisha Khatun.
I've heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of respondent number 2 and 3, and Ms. So-and-so appears on behalf of the respondent number 1. Respondent number 1 is not there. Respondent numbers 1, 2, and 3.
I am for
Uh,
4, Lordship. 4 was later
He did.
included.
Who also appears for respondent number 4.
My lord, may I take today's leave, my lord? My lord, I want to see if there is any scope, my lord, because the amount they have received from the, my lord, MSCT court is very less, my lord.
Who
Only
what?
3 lakhs, my lord.
I'll appeal there against.
If there is
I'll
any,
appeal there against. This has nothing to do with this.
my lordship.
Sorry. Petitioner herein has approached this court, being aggrieved on the inaction on the part of the respondent authorities to make payment of the ex gratia amount to the petitioner in terms with the notification dated 15/11/2024, 2014.
14, my lord.
15/11 or 6/12?
They have placed the notification dated
6/12/2014.
This would by finance department, not their notification.
What? Which one?
Page 31, my lord. And page 32 is the head, my lord.
It has no business. This is on the basis of that. This is only for the purpose of sanctioning the power.
My lordship.
On the basis of the 15/11/2020 notification. So the issue involved in the instant proceedings, stands concluded, is no longer res intriga in view of the judgment passed by the learned coordinate bench in the case of so-and-so versus so-and-so, dated so-and-so. In view of the judgment and order dated so-and-so in the case of so-and-so versus so-and-so, the judgment and order dated so-and-so passed in the case of so-and-so versus so-and-so. Wherein the learned coordinate bench of this court categorically observed that the ex gratia payment in terms with the notification dated 15/11/2014 is not available. It is only payable when the vehicle which had caused the accident is not identifiable. In the instant case, a perusal of the application so filed by the petitioner before the Deputy Commissioner, Kamrup Metro, which is annexed Roman 9 to the writ petition, categorically shows that the vehicle in question was a Bolero pickup van bearing registration number AS21C9685. Under such circumstances, it is the opinion of this court that the petitioner herein is not entitled to the compensation, is not entitled to the ex gratia payment in terms with the notification dated so-and-so in view of the judgment of the learned coordinate bench in the case of so-and-so supra, for which accordingly the written stands dismissed.
Obliged.
But if the issue involved in this two writ petition probably already decided by your lordship.
Which one?
Notification 56 has been satisfied by your lordship.
Huh?
Force major notification issued by the department. There are two notifications issued, 9 of 2020 and 56 of 2023.
Yes, what is your case? What is it challenging?
Notification 9 and 56.
Yes, your lordship.
56 has already been decided by lordship, setting aside notification. Against that, we preferable, but there is no stay order. And ultimately, the issue is pending before the Honorable Supreme Court. The notification 56 has already been decided by lordship in writ petition 3585/2024. Judgment dated 19/9/2024. In view of that judgment, lordship, both the writ petition may be disposed of.
And what is the other matter?
Same lordship.
Your lordship, similar to item number 30. Your lordship, my
But I have not interfered with the notification
Yes,
number
Lord,
9.
56 lordship set aside.
I've
But
only
9 has
interfered
not,
with 56.
lordship has not touched the notification 9.
Hmm?
Notification 9 has not been touched by lordship.
No.
But notification 56.
Here, there is anything as regards to the notification number 9 which is being put to challenge? No.
Lordship, it was issued after 56 was issued subsequently, lordship. That was interpreted by lordship because it was no sanction of the GST council.
So what about 9? Anything has happened in some courts? It has been.
It is pending before Honorable Supreme Court, lordship.
No, that is there, but some courts have held about 9.
No, lordship, 9 has been not been challenged.
Interfered. So the impugned order
Lordship.
in Brahmaputra Teleproducts is where?
Annexure 8, page number 112.
Hmm?
Annexure 8, page number 112.
Page?
112.
Proposed notice referred to under so and so, since no payment has been made within 30 days of the issuance of the year by on the basis of documents available with the record educator, demand is created for the reasons of detailed lecture. There's no order. Apart from that order in original, nothing is there. Oh, Mr. No order in original.
31 is lordship. I'm not in 31.
No, this one, no order in original. This one.
This one only. This is.
My goodness. Heard your name?
Yes, Sarkar, your lordship.
So and so the learned counsel appearing on behalf of the petitioner. Mr. Kyle appears on behalf of the respondent numbers 1 and 2.
One lordship, Union of India.
Central Board of Indirect Taxation
For that I can appeal, lordship.
and Union of India Finance
Lordship.
1 and 2. Mr. So and so appears on behalf of the respondent number 3 and 4. The present petition been filed assailing the order dated 6/12/2023, order dated 30/4/2024. for the financial year 2018-19, whereby the petitioner have been imposed an amount of tax to the tune of rupees 36,86,748 along with interest and penalty. It is the case of the petitioner that the said order dated 34/2024 be said to be an order passed with Section 73 of the Assam Goods and Service Tax Act 2017. Inasmuch as the order do not contain order is not in consonance with Section 75 of the Assam Goods and Service Tax Act 2017. Counsel appearing on behalf of the petitioner further submitted that the said order is also beyond the period of limitation so provided in terms with Section 73(10) of the Assam Goods and Service Tax Act 2017. Inasmuch as there was no notification issued in terms with Section 168 capital A of the Assam Goods and Service Tax Act 2017 in short period, thereby enlarging the period of limitation the learned counsel further submitted that though the central government have issued a notification dated 56/2023 CE, na? What is the name? 56/2000?
56/2023 days central tax.
This
No.
less central tax.
Not dated 28 December 2023.
The same cannot be applied qua the Assam General qua the State Act. And additionally, the said notification dated so and so, the bearing number so and so, dated so and so have already been set aside by this court. Case of, what is the name? Borkotaki.
Borkotaki printers. Print media services.
So and so.
WPC 853585.
It's reported somewhere, no?
Yes, lots. SSC on. 2024 SCC online, Gauhati page 1557.
2025-139 ZSTR 602 Gauhati. Gauhati Print and Media Services and another versus Union of India and others. This court have heard the learned counsels appearing on behalf of the parties. Duly peruse the materials on record. In the judgment of this court in the case of Borkotoki Print and Media Services and another, Supra, this court have duly taken note of at paragraph number 50 that the state of Assam had not issued any parameterial notification like the central notification for the period or after April 2024 for the financial year 2018-19 and for the period on or after July 2024 for the financial year 2019-20. Further takes note of that the period within which the period of limitation as stipulated in section 7310 of the State Act for completing the assessment for passing the order passing an order under section 73(9) of the State Act for the financial year 2018-19 ended on 31/12/2023. Taking into account that the order was passed in the instant proceedings for the financial year 2018-19 was passed on 30/4/2024. The impugned order dated 30/4/2024 is contrary to the provisions of section 73 of the State Act and as such cannot be sustained in law. In addition to that, this court also duly takes note of that section 75 of the State Act and more particularly subsection 6 of section 75 makes it clear as to how the order has to be drawn up. In the instant case, a perusal of the impugned order dated 30/4/2024 would show that the said order under no circumstances can be said to be an order drawn up in terms with section 75(6) of the State Act. Further to that, the said order was also passed without providing any opportunity for hearing to the petitioner, which is also the mandate in terms with section 75(4) of the State Act. Consequently, it is therefore the opinion of this court that the impugned order dated 30/4/2024, which is assailed in the instant proceedings, cannot be assailed in the instant proceedings and enclosed as Annexure Roman 13 cannot be sustained in law. Next, accordingly, the writ petition therefore stands disposed of with the following observations and directions. First, the impugned order dated 30/4/2024 passed for the financial year 2018-19 is in violation to section 73 as well as section 75 of the State Act. Accordingly, the same is set aside and quashed. Anything more? Anything more? This is done for this. Now the second one is 56, no?
56 and there is a order dated 13/3/2024. Is 39.
Page
39.
here the order is there.
Yes, sir.
Show cause notice is there.
Yes, sir.
The order in original is there.
It will be covered by your lordship judgment 56.
Your lordship, I'm not aware, actually, your lordship, my senior is not here today, so the matter may kindly be taken on 4th and 5th of August, your lordship.
We do one thing, we vacate the interim order.
No, your lordship.
I'm setting aside the order, you have objection.
No, your
Then?
lordship. Your lordship, my mistake.
Name.
P. Sharma. P.
Lord
Sharma.
P. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. X.C. Kyle, the learned senior counsel, as well as the standing counsel of the CGST department,
3 to 6.
assisted by Mr. K.J. and accepts notice on behalf of the respondent numbers, appears on behalf of the respondent numbers 1, 3, 4, 5, and 6. Mr. B. Chaudhary appears on behalf of the respondent number 2. The present petition has been filed assailing the order dated 13/3/2024 passed by the
Assistant Commissioner.
Assistant Commissioner, Goods and Service Tax, who is the respondent number 4 in the instant proceedings under section 73. It is done under what? 73.
23.
Of the Central Goods and Service Tax Act 2017, for short, the Act of 2017. It has been submitted at the bar that the impugn notification, the impugn order is contrary to the impugn order, that the issue involved in the present proceedings is squarely covered by the judgment passed by this court in the case of Gauhati Print and Media Services and another versus Union of India and others, reported in 2025, 139 GSTR 602 bracket Gauhati. First line too. The present petition has been filed challenging the notification dated 6/2023-CT dated 28/12/2023, as well as the order dated so and so, you can call, na? It's been submitted at so and so. This court have duly taken note of the judgment passed by this court in the case of Gauhati Print and Media Services and another Supra, whereby the notification dated 56 oblique 2023. CT was declared to be ultra-virus the Central Goods and Service Tax Act. This court have further. This court had further, in the said judgment, interfered with the impugned orders in original, so passed under section 73(9) on the ground that these orders were passed beyond the time period prescribed under section 73(10) of the Central Goods and Service Tax Act 2017. Full stop. Taking into account the above, comma, it is also seen that the impugned order in the instant proceedings was passed on 13/3/2024, and the period of limitation for filing for passing the order under section 73(9) of the Act of 2017 for the financial year 2018 and 19 was up to 31/12/2024. Under such 31/12? 23. Under such circumstances, the impugned order under such circumstances, as this court have already, as this court in the case of Gauhati Print and Media Services and another Supra have already held that the notification number 56/2023-CE dated so and so to be ultra-virus, comma, there is no requirement for passing us again a similar declaration. Be that as it may, the impugned order dated so and so 13/3/2024 cannot be sustained on law in view of the same being passed beyond the period stipulated under section 73(10) of the so and so. Accordingly, the instant petition therefore stands disposed of with the following observations and directions. The impugned original order in original dated 13/3/2024 for the financial year 2018 and 19, isn't it?
Yes.
Is set aside and quashed.
May it please your lordship. My lord, matter related to acquisition of my land, my lord. Acquisition of the land. My lord, here connected to writ petitions were already disposed of, my lord, with a direction I have.
Award has
Will,
been passed, my, so award has been passed, my.
yes,
This is the copy.
I have got a copy today, my lord. We would approach the district magistrate.
You got the money?
Not yet. No,
What
my
is your case?
not yet.
Enhancement of the-
And for enhancement, my lord.
No. Award is how much? What are you challenging here?
Challenging the award is less, my lord. It is
Huh?
He is seeking enhancement, my.
enhancement.
It has to go to the reference. Award has already been passed. That award list I have provided. Serial number 7 is the application.
You have got money.
Not yet, my lord. That part was,
Award to only copy.
my lord, that part, my lord, I'm not.
Your payment is there now, make payment to the petitioner, it is pending. Why are you going there? You can very well challenge it by way of this. Why you are now finishing up with that order? Unless you don't care, tomorrow if you don't get any money there,
Yes.
are you going to wait? Yeah, pass the award, so first get the payment and then give us, you withdraw, say that you go there. In the
I-
meantime, you are at liberty to approach under 64.
I'll take instruction to that, whether payment is made or not, my lord. Yes, my lord.
Mr. T.H. Hazarika, the learning counsel appearing on behalf of the petitioner submits that the petitioners have been duly informed that the award has already been passed.
Yeah.
In that regard, Ms. M. Borman appearing on behalf of the petitioner respondents have placed before this court the award statement which is kept on record and marked with the letter X.
Your Lordship, I am appearing for respondent 5 and 6.
X. Ms. M. Borman submits that the names of the petitioners are at serial number
7, my
One petitioner, yes, ma'am.
serial number 7. Seven, na?
Maybe
7 and 8 also, my lord.
Serial number?
7 and,
7 and
7 and 8, my lord.
Are at serial number 7 and 8
Yes.
of the said award statement. From the above, it is therefore clear that it is therefore apparent that the first relief so sought for in the writ petitions stands redressed. Court inquired with Mr. T.H. Hazarika, the learning counsel appearing on behalf of the petitioners as to whether the petitioners have received their compensation. He submits that he would obtain instructions in that regard. Mr. T.H. Hazarika, the learned counsel, further submitted compensation so awarded is too inadequate. The same have not been done in terms with section 26 to 30 of the right to fair compensation so and so. It is the opinion of this court that if the petitioner is aggrieved by the inadequacy of the compensation, the petitioner has to approach the reference authority by filing an application under section 64 of the Act of 2013, read with. This is done under the Assam, which one? Land and Requisition, no? Read with. And has to approach, this is the award made under what? This must have been done under the Assam Land Requisition and Acquisition Act, isn't it?
Yes.
Has to approach the authority in terms with section 12 of the Assam Land Requisition and Acquisition Act, 1964. Read with section 64 of the Assam of the right to fair compensation in Namtulekiri. The counsel for the petitioner submits that the same shall be done accordingly. However, on the question as to whether the petitioner have been paid the compensation, the instant writ petitions remains pending on the aspect as to whether the petitioner have been paid the awarded compensation. However, on the aspect as to whether the petitioners have been paid the awarded compensation is the aspect for which the present writ petition remains pending, and an update be placed before this court on the next date.
Yes.
List this matter on 19th of August 2026.
My lord, for the purpose of 64 limitation, my lord, it may be running from today because I have received the copy today because other.
Mr. Counsel, I have put section 12. Section 12 has no limitation.
All right, ma'am. Deeply obliged.
You file it immediately. What is this? Same name petitioner?
May it pleases your lord.
What is this?
Your lordship, this is the item 36 is the enhancement for compensation.
You got the money?
Some
Payment?
amount we have received, your lordship. On the last occasion, 21/3/2025, they sought time to seek instruction, your lordship, in this matter. And in item number 36, they have filed one affidavit, your lordship.
Did you approach the circle officer?
Lordship, the petitioner was hospitalized, so he could not approach.
The counsel appearing on behalf of the petitioner seeks for some time on account of hospitalization of the petitioner. Accordingly, list this matter on 26th of August 2026. In the meantime, the petition counsel for the petitioner shall obtain the instruction as to whether the petitioners have approached the authorities concerned for the payment of compensation.
Deeply obliged.
What is this?
Lordship, in the first case, our grievance is that Lordship, land already acquired, Lordship, we have no objection, but boundary set out by the authorities more than the acquired land. That is our grievance, Lordship. And our first petition file, Lordship, at the very initial stage, while the 3A notification was published, but subsequently, Lordship, 3D also published. So first one is infractious, Lordship.
Has the land been acquired?
Lordship acquired.
Boundary given?
Boundary given, Lordship.
Then what is there?
But Lordship, it is more than the acquired land.
Additional district commissioner says that it is within the right of way. Yes.
Lordship, may may direct the authority matter may refer to Lordship before the district judge, Lordship, to whether the claim of the petitioner and the respective party is correct or not. That aspect may examined by the district. Otherwise, he is a clear case, a 4 kata land was acquired, that I have no objection, but boundary according to the petitioner is more than the 4 katas of land. It is almost 7 kata, that's why he is aggrieved. He has a total land of 11 kata, out of which earlier occasion 2 kata already acquired. Remaining 9 kata, out of 9 kata, in the by the present proceeding, 4 kata more of the land was acquired. That thereafter remain 5 kata, that is not there, Lordship. That is, he is actually aggrieved by that, Lordship. And I have stated in para 10, Lordship, of my writ petition and 11.
Where's your land in the 3D notification?
Lordship, 3D.
Serial number?
Lordship. Page number, Lordship, 39.
Huh?
39. Serial number 82, Lordship. 0.0322.
Hectares.
Lordship.
How much that land is?
It is, Lordship, almost 4 kata, Lordship. Almost 4 kata.
Sure.
Lordship.
No. How much is one katha?
In the Parakpally, it is 4 kata of
How much is one katha? 2,880 square feet. Isn't it? 144 lesas is one, 144 square feet is one lesa.
Lordship, but there is some difference in the
This is-
Parakpally
this is
Lordship.
where?
In the Parakpally Lordship, it is
This is Barak Valley.
Lordship, par biga include 20 kata Lordship.
Okay, so how many lesas are there? How much square feet is one katha? Barak Valley?
Lordship,
Yeah, you are coming out there. Then 720 square feet
Lordship.
is one katha.
Lordship.
So they have taken 3,465 square feet. How much land they have taken?
3,000. No. 720. Almost 5 kata Lordship.
4.81,
Lordship.
almost 5 kathas. So they have taken 5 kathas. So they say it will be the right of way. Then what to do? Now, whether a reference is possible in respect to the area,
Lordship, it is
is it possible?
Lordship, regarding the
Can you take one? As of now, I knew only about entitlement apportionment. But compensation. No, reference code have no business power. Reference code only comes under 3H4. As regards the area of the land, it is the competent authority who has to do it.
so Lordship,
The competent authority has said that it is within the right of way.
Lordship may dispose.
How? How do I dispose it? Should also be happy. Don't you think so?
Lordship.
You file a short affidavit.
Lordship, Lordship.
Competent authority of land acquisition is you.
Lordship.
File a short affidavit. Let the council also be happy.
Lordship.
Short affidavit that it is, then you will say.
But in this case, Lordship, I have not.
She cannot, if the NHIDCL council produces it, then obviously there is something very wrong. Requiring authority takes over, produces the document. It is the you who have to produce it.
I have to bring this bioweapon appeal.
Dispute in the instant proceedings, both the petitioner, is that certain area of land beyond what has been acquired in terms with the notification dated notification under section 3D of the National Highways Act 1956 have been taken, thereby encroaching upon the petitioner's land. It is the opinion of this court that the said aspect be brought on record by the competent authority of land acquisition as to whether any land beyond what have been declared, which have been acquired in terms with the notification in terms with section 3D of the National Highways Act 1956 have been taken from the petitioner. Say the affidavit be filed within a period by 21st of August 2026. List accordingly on 26th of August 2026.
May I please, my lord? My lord, I have placed this instruction on the basis of my lord's order dated 17/2/2025, where my lord has directed NHIDCL to produce this. Lordship, whether any land has been taken.
I understood, madam. The
Lordship.
problem lies there.
Lordship,
Although if I have passed the order, I have
Lordship.
passed it wrongly.
lordship, lordship,
The order should have been given to the competent authority.
lordship,
They can say so. If
lordship,
for you to, obviously you will say no.
lordship, lordship, lordship. All right. My presence may kindly be recorded for one.
Oh, yeah, names are there. Miss So-and-so appears on behalf of the
Respondent one is my lord.
NHIDCL. NHIDCL.
NHIDCL.
Infructuous. The writ petition is infructuous, taking into account that the petitioner, the issue involved in the instant writ petition is infructuous in as much as that the panchayat elections have already been held on in the year 2025. Accordingly, the writ petition therefore stands closed. So and so appears on behalf. What it is?
Hello, this is a land acquisition matter, Milan. Land acquisition.
Before starts, Lordship, we have received instruction with regard to both the cases, Lordship. Sought accommodation to file our affidavit, Lordship.
What is the interim order passed?
That is on 17/3/2025, Milan.
You are in occupation of the land.
We are continuously in occupation, Milan. Only a portion of the land was under the EMI, but they have already shifted their office to their respective places, Milan. They have already established
The
there.
respondents in the BTC as well as the state.
Okay, I have filed affidavit now. In the second
Respondents
case-
in the BTC submits that they have received the instructions
Yes, Lordship.
and would be filing the affidavit within 3 weeks. Accordingly, list this matter on 28th of August 2026. Interim orders passed earlier shall continue till the next stage.
Milan, a small submission, Milan. The reply to the opposition filed by Respondent 5, Milan, we have filed it on 25th of September 2025, Milan. It has not been tagged in the file, Milan. Observation may.
It has been also, attention has been drawn to this court, to the affidavit in reply filed to the
Opposition filed by Respondent 5.
of the respondent number 5.
Milan.
You have filed an affidavit in reply.
In reply on 25th of September 2025.
Against whom? Who's
Against
affidavit?
the Respondent number 5, Milan.
Of the respondent number 5. The registry shall make the necessary inquiry and place the same before this court.
Masuk.
Mr. H. Das, what is there?
Subdivision Land Advisory
When
Committee,
you
my lord.
come out here, I think it with what type of matter you have come.
But a Land Advisory Committee, my
You
lord.
don't come with something which is good, I mean,
10, my lord, 10
process is writ large anyways, what is
Sir,
this?
10, my lord, page 32.
On an application filed by the petitioner for settlement, a proposal was submitted to the respondent number 6 proposing settlement of the land. The said proposal was approved by the man.
Deputy Commissioner, my lord.
Okay, the settlement has not been granted.
Not granted, my lord.
Now, my lord, the department has sought for some clarifications from the district commissioner, concerned district commissioner, in pursuance of that letter at page 32. And my instruction says, my lord, that it will require, my lord, the approval of the cabinet, my lord. So it will now be placed before the cabinet.
Is 32.
32, my lord, Deputy Commissioner wrote to the my lord, Additional Chief Secretary, my lord.
Eh?
Additional Chief Secretary, my lord, settlement of land in favor of so-and-so petitioner. Because, my lord, zonal value also fixed, my lord, and it has to be approved by the defense person, my lord.
Hmm?
Defense, he was a defense person earlier.
Oh, so reduce the amount.
Not reduced, my lord. Amount 3,50,000 fixed, my lord.
Something, my lord, some discrepancy with regard to, my lord, valuation of the land, zonal valuation of the land, my lord. And then, my lord, now my instructions from the department, it says, my lord, that it will be now placed before the cabinet, my lord, on receipt of the detailed information from the district commissioner as sought for. Lordship will kindly accommodate me for 3 weeks,
Person
my
in the
lord. It will
defense.
be, my lord.
Defense.
Defense, army man. It is mentioned here and so. Page 10, Annex 10.
Mr. Arbopujari, appearing on behalf of the Revenue Department, submits that the proposal as regards the settlement of the petitioner, of the land to the petitioner, is likely to be placed before the cabinet.
Cabinet, my lord, upon receipt of, my lord, detailed information from the district commissioner, which the department is
Now,
coordinating.
obtaining certain informations from the district commission. Taking into account the above, list this matter on 7th of September 2026 for an update.
My lord, my lord.
The respondents herein shall duly take note of that the petitioner herein, the retired serviceman,
Army man. Serviceman.
retired serviceman. And as such, the respondent authorities shall take due note for an expeditious resolution to the present dispute.
I'm so obliged.
Yes, what is this?
If they have challenged the notice on the ground,
Notice.
issued by the DGGI. But if their main contention is that single notice for multiple years has been issued.
What?
Single notice for multiple years has been issued.
That issue?
Yes, Lordship, that is covered by Lordship judgment, Tata project.
Is it stay?
Yes, Lordship, earlier some other advocate was appearing, thereafter it was allotted to me.
No stay. I don't understand, first of all, how can there be a stay? I know this no coercive action is a dangerous term.
Yes, Lord.
Honestly, either you stay the notice or don't stay the notice.
Right.
But no coercive action means the departmental authorities are also they are also scared. If they take any action tomorrow, contempt.
Yes, Lordship, this is.
What is the case? Has been clubbed together for such a reassessment which is not permissible under law. In the further case of the petitioner that there is no an entire amount was paid so and so. Whether the action contends that in the facts of the year, the petition respondents have exceeded the detained in taking up AI as a fraud. So,
Lordship, we kindly be granted 2 weeks time to file our affidavit, additional affidavit. Your
why do you need? The issue is settled by my judgment.
Lordship, we need to bring certain documents on record, Your Lordship.
We have a very strange thing, Mr. Kyle. Morning, the CGST council takes time.
Unfortunately.
I refuse. Now the petitioner council takes time.
Lordship, interestingly, Lordship judgment has been affirmed by the division bench also.
Yes, the matter is already over, matter.
Lordship, last opportunity may be given
For what?
to file our additional
Tomorrow.
affidavit.
Why do you need an affidavit? I'm not concerned with the affidavit. The question of a stay of a show cause, it is never heard of. Why do you need a stay of the show cause? Tomorrow, if you, because of the stay of the show cause, this is going to happen. There's not a so-called stay, no coercive measures. They should be directed to submit their reply, and after that, if they, at best, the court could have passed an order that no, that the order made, the order if passed shall not be, the demand should not be further proceeded with.
Lordship.
Recovery of demand should be made. That could have been the best order. Because otherwise, the limitation, how do you take care of it? Anyways, we do one thing. Tomorrow. Not interested in.
Next week, your lordship, next week. She must.
Friday. Friday, get hold of your seniors. The issue involved in the present proceedings is squarely covered by the judgment passed by this court in the case of
Tata project.
Tata Projects Limited versus Union of India, na?
Lordship.
Reported in, it's reported in SCC online.
It is reported in SCC online. Lordship.
Yes, I have mentioned somewhere there. Anyway, SCC Silo, SCC online. Whereby this court had made it categorically clear that it is permissible to issue a consolidated show cause notice for different financial years and also pass a consolidated order for different financial years. Under such circumstances, the issue which have been raised in the petition, in the present petition, do not survive. This court also is of the opinion Ms. So-and-so appearing on behalf of the petitioner seeks for an accommodation on account of her senior not being present. List this matter again on 3rd of August 2022 at 2 p.m., showing it to be parted. On 3rd of August at 2 p.m. Court is further, in view of the judgment passed by this court, in the case of Tata Projects, Supra, is not inclined to extend the interim order which was passed on 19/5/2025. Paucity of time, Mr.
I'm the newly engaged.
You have been engaged in a matter where you don't have a case.
But if I will.
Isn't it?
No, I have. Get the amount.
Mr. Sharma, first of all, nobody engaged. You are mostly there for the fishery department. Somewhere I find you are writ petitioner, and now that is a case which is very sad for me to dismiss it.
I will try to make out a case.
Fantastic. Argue then.
No, Lordship, I will file.
You are going means it is still in your mind that you are thinking of making out.
No, I have gone through it, Lordship. Here, the thing is that I have gone through it, Lordship. It all happens through the Jamabandi copy, Lordship. Jamabandi copy. Lordship, here the fact is that the DAG number, which is not there, Lordship.
This is not the case where this court should entertain. You have that particular authority, no? There's an authority out
No,
there where
Lordship,
you should.
here, Lordship, the DAG number is that, Lordship, DAG number is there is a dispute regarding DAG number, Lordship, here. Here
How can this court decide which DAG number it
No,
is?
that cannot be decided, but
That can be decided by that authority who is there, the district judge.
So that part is there, Lordship. But
That part is there, so the district judge has better authority
Lordship,
to
they-
call for evidence.
Then also, Lordship, give me 1 day time, Lordship.
Oh, yes. Yes, you try to make out again. Mr. P. Sharma, the learned counsel, submits that he has been recently engaged in the matter and requires 1 day to prepare the matter. Tomorrow?
Day, Lordship, 1 week, Lordship.
1 week.
More than 1
1
week.
week.
One more day.
Okay,
Lordship.
list this matter on 21st of August,
My
2026.
lord, 21st, I may be now here, not after 21st.
21st of September?
Lordship.
September, I am not there. After
Lordship, they have
21st August, no.
21st of October?
21st August, I am not here, my lord.
21st September, Lordship. There.
Okay, 21st of September is closed. That is why he's saying
No,
have it on 23rd of September.
Lordship. Offline.
There's no interim order, no, Mr. Mitro?
no, no.
Let him also be.
Amount has already
He,
disbursed.
Mr. Sharma is tired of making submissions as regard fish. So let him be doing something better apart from fish. Yes. Yes, what is it?
My lord, here in this case, my lord, my rejoinder affidavit is ready. Within 3 days, I will file, my lord.
What is this matter? To ensure that the grass hotel is fully functional. What is your matter, Mr. Counsel?
My lord, regarding my lord, offline and online mode of the my lord payment of my lord e-khazana. They introduce a model, my lord, which is my lord not viable, my lord. And
now what is happening?
Now, my lord, because of the interim order,
Existing
both model, my
mode
lord,
for
offline and
collection
online, both
disbursement
model are
of
working.
Khazana be maintained. The interim order, however, would be reconsidered after obtaining. So this court had passed an order thereby changing the process of payment of money.
No. The old process, my lord, as well as the new process also continue. So that's why, my lord, my in affidavit, my reply, I have hitting, I will place my.
But that should be only permissible squad of pity. You are facing the difficulties,
No,
others
my
are
lord.
not.
All, my lord, everybody.
But why this will be opening a Pandora's box for everybody? We are not on a PIL.
My
It's a
lord.
writ petition there, where you are the person aggrieved.
No, we are the Mujara Association.
You are the Muzada Association.
Yes.
Muzada Association, government officers are also filing against government. You have serious troubles.
No, because the.
Are they not your appointees? Huh?
I'll place everything because already the issue has already been decided earlier, my lord.
Anyways, I have to rise early.
My lord.
I have a matter there. Anyways, Mr. T.J. Mohanto, the Learned Senior Counsel, appearing on behalf of the petitioner, submits that the petitioner would like to file an affidavit in reply to the affidavit in opposition by the respondent number 2 and 3. Affidavit in opposition filed in 19/9/2025. I am not going to grant you time. Sorry.
No, it is already ready, my lord. I within
So
2 3 days.
what?
Within 2 3 days, I will file.
Absolutely no. Okay. I give you 2 years vacating the interim order.
No, my lord, it will be difficult, my lord.
Difficulty.
No, within
Mr.
3 days, I
T.J.
will file, my lord.
Mohanto, the Learned Counsel, appearing on behalf of the petitioner, submits that he is not prepared with the matter. That is a better?
No, my
Can I
lord,
adjourn the matter
my
to
affidavit
petition?
is ready. Within 3 days, my lord, I will file.
Which one do you want?
My lord.
Either I vacate the interim order, because I can't say that 1999 and now an interim order is continue. Or I say that, okay, Mr. T.J. Mohanto is not prepared with the matter, or his assisting counsel is not there. Something to that effect.
My affidavit is ready, my lord. Within 3 days, my lord.
I'm not going to say. Due to paucity of time, the matter could not be taken up. Accordingly, let the matter be listed again on urgency.
We have already filed our affidavit, my lord. They are complaining about, my lord, introduction of the online system.
Which is contrary to the judgment passed by this honorable.
Is the matter on 7th of August 2026. Interim order shall continue till the next stage.
Deeply
In the meantime, if you file, I'm not going to.
My lord.
I'm so obliged.
What? What is the matter about?
Lordship.
Any urgency matters? Right, I'm meeting up.
Lordship, in this case, petitioner number 1 and 2, that is Mr. Dhiren Kalita and Nayanmani Kalita, have their plot of land in the name of their late father, Dharmester Kalita, in DAG number 508, 534 and 535 of Patta number 1, village Sastapara, Mauza.
Who is in possession of the land, madam?
Owner, they are the possessor.
You are the owners, you are
Yes.
in possession.
Yes, Lordship.
You want them to acquire your land.
No, Lordship.
That's your prayer.
Yes, yes, but Lordship, they have illegally constructed road.
So they are in possession. That is why I'm asking you, who is in possession of the land?
Oh, yes, Lordship, they are in possession without publishing any notification, Lordship, which is
Yeah,
required
that
under
means-
law.
Lordship, we have not filed our affidavit, Lordship, yet, Lordship, but after going through the repetition, Lordship, there is against which order, against which acquisition they have come up before this court, that is not clear, Lordship.
They are saying,
Clear,
no,
Lordship.
they are saying that they are the owner of a plot of land
Yes, Lordship.
where some construction is being carried out by you.
Yes, Lordship, without
So
publishing.
either you stop construction or acquire the land. This is the simple case.
They have not given us any compensation also, without acquiring the land, Lordship. They have not acquired the land, Lordship.
You understood?
And petitioner have already
Yes.
submitted
The
applications.
compensation, they are
to the circular office.
approaching before this court regarding the compensation, if the
No.
land has been acquired by the authority.
If you acquire. First they say they are the owner of a plot of land.
Yes,
In that plot of land, you are making some construction.
Yes, illegal.
That means you are possessing and have taken over the land.
Mm.
And therefore you cannot take over the land in view of Article 300A. This is the petitioner's long and short case.
Yes,
Okay?
Lordship, I'll take instruction also.
BTC. Ms. N. Chaudhary, the standing counsel of the BTC, submits that the affidavit on behalf of the BTC would be filed within 3 weeks. List this matter on 21st of August 2026. In the meantime, the affidavit be filed. Any urgency? No urgency?
No urgency, Lordship. Obliged, Lordship, deeply obliged.
All interim orders would be extended to a date, and if anybody needs a date, they will give you.